Today is Wednesday, August 17th, 2011, and the time is 1:05 p.m. Will you please all rise and join me in the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Welcome, everyone. It's great to see so many members of the public here in attendance today at this meeting. I have a feeling I know why many of you are here. It's a special day, but let me introduce a few folks around the room first that are helping us. Well, I'll go through roll call first, and then we'll introduce the other guests. So let's start with roll call. Vice Chair Freeman.
Here.
Vice Chair Herrera.
Here.
Commissioner McNulty.
Here.
Commissioner Sturts.
Here.
We have a quorum. And the other members of our team, our Executive Director, Ray Bladine, is sitting here in the blue shirt and tie. If you need to talk to him, please feel free to ask him any questions throughout the day. Our Deputy Executive Director, Christina Gomez, is also sitting with Ray, not at the moment, but you'll see her soon. Our Public Information Officer, Stu Robinson, is here. Our Chief Technology Officer, Buck Forst. Our Legal Counsel, Mary O'Grady and Joe Canefield. Our mapping consultant is here, Ken Strasma and Andrew Dreschler. And am I forgetting anyone else? And then we have a team of outreach coordinators too, actually. We have Christy Olson, Shane Shields, and Lisa Schmelling, who are all here too. And so any of these folks would be happy to help you should you need anything today. So moving to the next item on the agenda, this is a real treat. It's a rare privilege to have the opportunity to be in the presence of, let alone introduce, a true statesman and an American hero. Her list of accomplishments, awards, and honors is too lengthy to detail here, but notably, it includes our nation's highest civilian honor, the Presidential Medal of Freedom. There's one aspect of her past that I find especially intriguing, that she served in all three branches of Arizona state government before being nominated by President Reagan to be the first female member of the Supreme Court of the United States. The Arizona Independent Redistricting Commission is very pleased to have with us today the Honorable Justice Sandra Day O'Connor.
Hey, I'm the one that's honored. Delighted to have a few minutes. I'm going to try to be brief. But I'm here for a couple of main reasons. I want to thank each and every one of you for tackling this job. It's a hard job. And I'm sure about now in the process you're saying, why did I ever agree to do this? But somebody has to, and you're the somebodies. And I'm not here today as a judge or a former legislator. I'm here because I'm a longtime citizen of Arizona. You know, my family lived over in Green Lake County, near Duncan, out in the middle of no place. And Arizona's my home. I care very much about it. About its past, we're celebrating 100 years, and about its future. We do have a future. And part of what we accomplish is in your hands. And in recent times, we've noticed, not just here, but other places in our country as well, a lot of political gridlock. We've seen what I think may be an increase in partisanship and polarization on a good many issues. And what we have not seen enough of is thoughtful civil discussion on the issues that divide us, and an attempt to really develop a consensus as we go along on things that we're charged with deciding. And our democratic government is based on the concept of fair representation. And unlike many countries still in the world today, we enjoy the right to vote at the local level, state level, and national level. And to make that system work, we have to have legislative and congressional districts that represent our population. We didn't always have that, as you know. In fact, I remember the days when Greenlee County, Arizona, had 2 members in the legislature, and all of Maricopa County had 2 members in the legislature. Now, what kind of a system was that? Greenlee County had very few people at all. Maricopa County had over half the population of the state. And so I was present for those changes that recognized that population difference. And now what you're doing is to try to divide up the district so that it is fair and roughly equal in all respects, which it certainly wasn't when I grew up. And you have a very difficult job. I think you're going to be pressured by all sides to accommodate different agendas. And you're just going to have to listen to what many people who come before you have to say, and then you're going to have to put your thinking caps on and look at the data you have before you and try to be fair and impartial in drawing boundaries. And it's hard because inevitably, due to population changes, there will be some changes in boundaries from last time. And those changes never make everyone happy. So I guess you have to come to grips with that. You're apt to have a lot of criticism and a lot of unwanted publicity. But this is not an agency that's in there for a popularity contest. That's not why you're serving. And you just don't have an easy job, but thank goodness there were intelligent, decent people who were willing to take it on, and that's you. Now, redistricting is not an exact science, as you've already learned. There are lots of things you're going to have to decide based not entirely on the numbers. You have to weigh the competing interests and follow the legal requirements. Arizona, I think, is fortunate to have the law that it now does on redistricting. It looks like a pretty good one to me. And so you're able to make that work and be effective. And that's where you have to apply your skill and intellect to reach fair and appropriate decisions. And I think when the voters in Arizona passed Proposition 106 to take redistricting away from the legislature and put it in the hands of an independent redistricting commission, the voters in Arizona, I think, sent a special message. And that message was, we want to take partisan politics out of the redistricting process. And we want to create fair representation in our legislative and congressional districts. I think the citizens of Arizona have confidence in you as an independent redistricting commission to draw boundaries that aren't drawn to favor any elected official, any particular elected official or political party or special interest, but districts that will serve Arizona as a whole. And I wish all of you very well as you undertake this task. And I want to thank you again for your willingness to take this, what must seem to you about now, is a pretty thankless job on. Don't give up. Just do it well. We'll thank you later. But thank you for listening. Do you have anything you want to ask me? I can't answer any questions that will matter, but I don't want to cut you off if there's anything you want to ask me.
Any questions from commissioners?
Well, good luck to all of you.
Thank you very much.
So much.
We appreciate it. Thank you for those words of wisdom, Justice O'Connor. And thanks to the O'Connor House, Lucia Howard, for helping coordinate this for us today. We really appreciate that. I'd like to also recognize another gentleman in the audience. Bud Jones, the former Arizona Supreme Court Chief Justice, is here today, I understand. Oh, Jones. Your Honor, if you'd like to say a few words, you're welcome to. Please come to our microphone. Oh, okay, okay.
The thought occurs to me, listening to Justice O'Connor, that one of the main components of this process is the ability that this commission has to step forward and set an example for the other branches and for all of the other units in state and local government in Arizona. I love Arizona. I have lived here now most of my life. My father's people came here in the 1870s and settled in Prescott, and they were loyal Arizonans. And we must bring this state to a higher level and therefore avoid the polarization and the politics of this work, but step up and set an example for the rest of the state and let the rest of the state know that there are people who are willing to do this in that way. Thank you very much.
Thank you. Well, that was a very inspirational start to this meeting, and I thank you both for being here and sharing words of wisdom with us. Excuse me. Our next item on the agenda is the Executive Director's Report, a summary of most recent events and activities by staff. There won't be any action required, but our Executive Director, Raymond Bladine, will be briefing us.
After those comments, my Executive Director's Report seems pretty mundane. And it really is. I just wanted to comment that, as everyone knows, we finished the first round of public hearings. We had good attendance at all of the hearings we had. And on today's agenda, we have approval of a second round of hearings. And as you know, we sent out copies of that to you earlier so that we can get the locations approved and then start trying to move ahead to set up the specific places that we will be holding second round. Second round, we're expecting to start on September 18th, thereabouts, and hopefully by that time you will have completed a draft map and adopted that, which means the next several weeks will probably require a lot of meetings, probably more than one a week. And as all of you know, I've asked for information on availability, and we'll continue to follow up with you and see how we can all get together. I do want to comment, since one of the things that's very different this year is the streaming of our meetings and the ability for people to respond on the internet. Right now we have 11,146 subscribers that get emails from us about the meetings. We have had 11,483 unique visitors to the website. And we've also had a lot of viewers on the streaming, about 2,239 on that. So clearly the web page and the streaming is allowing the public to keep up with what you're doing. Finally, I will, by next week, have a budget report for you as to where we are. Still, most of the expenditures that have been going on this month won't be in for another month, primarily related to legal services that relate to some of the activity recently we've had unanticipated. So I will have something for you next week on that. And I think that pretty well covers it. We'll see you tomorrow in Casa Grande for our first official mapping meeting. And then again on Monday, the 22nd, following up on what the mapping people were able to put together at your direction. Thank you very much.
Thank you. Any questions for Mr. Bladine? Mr. Herrera?
I don't have a question. What I do have is I just want to congratulate the staff for all their hard work. I mean, the outreach that we've been doing, the staff and the commission have been doing since the beginning really is amazing. The number of people that were reaching out, and the number of people that are able to provide input as to the direction of the IRC and how it should go in creating the maps. It is really amazing. So I want to thank the staff and thank Ray and the commission for doing this.
Thank you. We all appreciate that.
Madam Chair.
Mr. Sturts?
Mr. Bladine, when speaking about the budget being delivered next week, what is this going to have history through what date? And how will you be breaking up the services that have been provided so far and through what date? And will you also be forecasting our expenditures, and how will you be forecasting those going forward?
I would basically be using, Commissioner Sturts, the same form that I'd submitted to you, I think it was last month, that shows the appropriation for last year and the current year, and then has the budget categories down it. I'll revise those budget categories, and probably the information will be based upon August 1st. That's why I was kind of cautioning. There's been a lot more expenditure in the last couple of weeks than there were in the month of August.
Okay.
It'll be the same format I'd provided you earlier.
In regards to services for the two consulting legal firms as well as the mapping consultant, will you be breaking those down by will they be just bulk numbers, breaking them down towards what the monies were applied to?
They would be both numbers for legal services.
Are you able to break those numbers down so that we can have a split of monies that would be spent towards the activities of the commission versus the activities of any potential issues?
Madam Chair,
Standing?
I'm sorry, but this is not on the agenda, so I want to make sure, are we able to discuss this in this detail without it being in the agenda?
Commissioner Herrera raises a good point. This really should be deferred till that budget discussion is properly on the agenda. And then we have some additional kind of legal issues in terms of how much of a breakdown of our legal expenses are appropriate in terms of the budget discussion, but we'll follow up with staff on that as well.
Well, then, Madam Chair, I'm going to suggest that when we get to future agenda items, I'll make some suggestions about the level of detail and the Q&A available to us when we have an executive director's report. Because this would be the time and place that I'd want to have the rest of the commission be able to drill some of these questions down.
Okay, thank you.
Thank you, Mr. Bladine.
Any other questions for Mr. Bladine? Okay,
Okay,
thank you, Mr. Bladine. I don't know if we want to take a brief recess at all, just to allow folks who maybe don't want to stay for the meeting. I don't know if we have people like that, but I didn't want people to feel like they were forced to sit through our meeting if they wanted to leave at this time.
Madam Chair, is there a photo op with Justice O'Connor? I mean, I'd love to take my picture with her.
Oh,
I don't know any celebrities. You're the only one I know.
I would too, but
Sorry,
I didn't know if that was appropriate. But if you're open to that, Justice
Are you-
O'Connor, maybe we could take a brief recess for 5 minutes and allow folks who don't want to stay to go, and we could also do a photo. Thank you. Okay. It's 1:23 p.m. We'll exit out of public session just for a brief recess. Thank you. We'll go ahead and enter back into public session. The time is 1:29 p.m. And I was neglectful in recognizing our court reporter today. Marty Herder is right up here up front, doing his usual great job for us. So we'll move on to the next item on the agenda, which is agenda item 4, legal briefing concerning the procurement of online services and commission selection of the provider. And I believe our legal counsel is going to be leading this discussion. Is that right?
Yes, Madam Chair. I was
Okay.
about to say Your Honor, but yes, Madam Chair. Joe and I were going to address this. And rather than going into detail, I might just kind of lead with a recommendation. We've reviewed the issues that were raised at the last commission hearing. We received a follow-up letter from Dave Cantelme, representing Fair Trust, that addressed some of the issues that concerns he had about the Avasia proposal. And so, and we reviewed those issues. And overall, we have the SRE bid or package that was at $116,000, Maptitude at $87,000, and the Avasia at $49,651. And frankly, when we looked at all the package, guess, bottom line recommendation would be to encourage perhaps the maptitude approach on this in light of, we have some legal issues here that have been raised, and in looking at the overall cost, looking at the original proposal, I was going to toss out that as a recommendation, notwithstanding any technical issues that are better addressed by others.
I should mention that since our last meeting, those three proposals were put on our website, so any member of the public can view those should you choose at azredistricting.org. Go ahead.
And Madam Chair, one other issue, whether it's a subcontract or a contract with the commission, we thought we could work out that detail in terms with Ray, Bladine, and strategic as a matter of what's going to make the most sense from an administrative standpoint. I believe they just did a purchase order for the maptitude purchases previously. These were listed as reimbursable expenses in the proposal, so I think either one will work. So wanted to follow up with that. And the procurement officer does have the authority to enter in a subcontract if they go that route, and certainly is within his authority as the procurement officer, but we obviously wanted to brief the commission and get its authorization with regard to which way to go on this one.
Thank you. Any comments or discussion among the commissioners?
Madam Chair,
Mr. Sturts?
I've had the opportunity for the last week and a half to be operating with Maptitude. Was provided the Maptitude grid maps that were provided by Strategic Telemetry for me to operate in. I find the program, the system to have a high level of ease of operation and a level of complexity of data management. And I will make the motion that we that we go ahead and ask our executive director to enter into a contract either by, if the contract is to purchase through Strategic Telemetry, I'm assuming that there will be no markup or transfer. This would be a straight through. If there's any cost efficiencies by going direct and not through Strategic Telemetry, or in the opposite direction, we would take that path. But to make it simple, I'd like to make a motion to authorize Ray Bladine to explore, negotiate, and enter into agreement for the acquisition of the online Maptitude software.
Is there a second?
I'll second that.
Okay, any discussion on that motion? Mr. Herrera?
Yeah, I'd like to have our legal counsel go into some detail on why you wouldn't recommend going with Avasia, or because I'm assuming that the people sending letters or that were opposed to Avasia at the meeting on I think the 3rd had some influence, but I want to know if we decided to go with Avasia, what would be the issue?
Madam Chair, Commissioner Herrera, I think there is, the signal we've gotten, there's some legal risk associated, and there's a cost difference to the state of, it's $87,000 versus $49,000, and just from a kind of a practical risk assessment standpoint, it seemed to make sense to, among other reasons, go with the Maptitude approach. We avoid some of the legal issues that are raised with regard to Avasia without making any final determination in terms of how those would play out. But I was not persuaded that when I look at the whole package of issues, including those that Commissioner Sturts raised in terms of practical usage and the other Maptitude that we're already using, it seemed to support the Maptitude recommendation as a bottom line recommendation.
Madam Chair.
Mr. Herrera?
Can you, I appreciate your explanation, but I still doesn't answer my question. What issues are you referring to? I mean, other than some of the issues that people brought up, that's their opinion. It's not necessarily, I'd like to see what the true issues are of not going with Avasia and what the legal ramifications if we were to go with them.
Yeah.
I don't see it, and I want to be able to understand.
Okay. Madam Chair, Commissioner Herrera, I'll rely on the communication from Dave Cantelmi in terms of what the issues were what issues.
Sure, those are his opinions. What are your opinions?
My opinions are, as I mentioned, that the better course is not to go down that path and invite and pursue a course that might require additional, that raises some legal risk at least. Maybe not significant legal risk, but when I look at the numbers sufficient there that it supports going with the maptitude. And one of the issues that they did raise, they have issues of sort of fairness to the other bidders, issues of whether there is a subsidy of a contractual obligation, of a nonprofit, and then also they raise whether there's some sort of political benefit to a certain group who may have used that nonprofit services in the past, and whether their experience with that particular software would give them an advantage over others who are not experienced with that particular software for whatever reason. And then they raised some issues with regard to the way the voting rights analysis had worked. Now, without fleshing out all those details, there was at least sufficient information, sufficient issues raised there that when I looked at the whole package, I thought I looked at it and decided I would recommend the maptitude approach.
And Chair, did anybody send any letters or documentation providing some contrary views to Mr. Cantelmi's letter?
Okay, and Mr. Canfield has some supplemental comments that he wanted to make.
But before you go, Mr. Canfield, I just want to see, did anybody send any information to the IRC, maybe stating their case why we should go with Avasia?
Madam Chair, Commissioner Herrera, I was working off the Dave Cantelmi legal letter that I have, and I don't remember receiving a specific rebuttal of that information
So you're making,
writing.
I just want to make sure, you're making a decision based on David Cantelmi's letter?
Madam Chair, Commissioner Herrera, and my independent review of the issues that he's raised in that letter.
Madam Chair, members of the Commission.
Canfield.
I concur in Mary's analysis. My review was not just based on Mr. Cantelmi's letter, although he did raise some legal questions. It was looking at the procurement issue with respect to this, obtaining this software. As I went back and looked at all this, it was clear that the proposal from Strategic Telemetry included an online mapping tool for the public to use as part of the proposal, because the Commission had asked specifically for how the consultants were going to propose the public have input in this process. They came back with some suggestions on what vendors they might choose. The question was raised as to whether or not that process would raise procurement issues. And frankly, after I looked at the law on this, if through strategic telemetry as proposed, then it works, and that's what was part of the analysis, because that was part of their proposal. They've obviously come to the Commission asking if the Commission wanted some input on it. But if it's not going to be through strategic telemetry, then, and the Commission wants to do it a different way, then we're going to have to do a competitive bidding RFP. And I don't think that that's necessary, but in light of the proposal, and after we looked at it, like Mary said, did the risk analysis, the legal issues that were raised, I think legally the Commission's on solid footing. If it chooses Maptitude, that's the software that the Commission and strategic telemetry are using to draw the maps. It integrates with them. It was a fair proposal, and it just seemed to work with us, and it alleviated some of the legal issues that have been raised.
Thank you.
Other comments from other commissioners or questions? Okay, well, we have a motion on the floor that's been seconded. All in favor?
Aye.
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 Any opposed?
Aye or nay?
So we have 4 commissioners voting for that. That would be Sturts, Mathis, Freeman, McNulty. 1 nay, that's Herrera. So we are authorizing our Executive Director, Ray Bladine, to explore, negotiate, and enter into a contract either through strategic telemetry or directly for this online mapping software, whichever is most advantageous, and this would be the Maptitude version. Okay, move on to the next agenda item, which is Agenda Item 5, discussion and possible action regarding contract modification with strategic telemetry to clarify possible clients and documentation of contracts regarding the Redistricting Commission. This has come up in previous meetings since we negotiated the contract with strategic telemetry, and I'm glad to see it's an agenda item today that we can all discuss openly. So who was going to lead that discussion? Is that Mr. Bladine or is that legal counsel?
Madam Chair, I was going to start, and then others may join. Yes, this, as the chair mentioned, this dates back to a prior meeting in terms of proposed amendments, and we looked at issues including screens within strategic from some of their current contracts and this contract and other issues, and a screen, which was one of the proposals, didn't make sense in terms of dealing with a small business such as strategic. But what made sense, it seemed, that to restrict during the life of this contract their ability to enter into contracts that involve candidate work in the state of Arizona. And so that would be one proposed amendment. And then the other, although the agenda says documentation of contracts, but we're really, regarding the Redistricting Commission, it's documentation of contacts. And this requires that they maintain a log describing the contacts that they receive, oral or written, about this contract, about this work. And it doesn't apply to the contacts they receive from staff and commissioners and us or at these public meetings, but it would apply to other written or oral communications that they get in the course of their work about the project. And so that's all, you know, documented and available, and adds to the transparency of the work that's being done. So that was the recommendation. Under the contract, the executive director, the procurement officer, has the authority to enter contract amendments, and so to some extent he wouldn't necessarily require commission approval for all contract amendments that might come up, but we thought it made sense to bring this back because it did originate with the commission, and so bring it forward for your review and consideration. And we have reviewed this with strategic telemetry, and so it's agreeable with, we would recommend it as council, and they've also agreed to the proposal.
Madam Chair.
Mr. Freeman?
Council, do you have proposed language for the two modification proposals you just described? Do you have language?
Madam Chair, Commissioner Freeman, yes, there is language, and that language also was available to the public as a handout. If you don't have it in front of you, I can pass it along, and I can also...
it was just directed to me. It was in my packet for today.
Okay, and if it's helpful, for the public who are listening, contractor shall not accept any work, contractor being strategic telemetry, related to candidates within the state of Arizona for the duration of this contract, which refers to their contract with the Redistricting Commission, including any extensions thereof. And documentation regarding documentation of contacts regarding the contractor. Contractor shall maintain a log describing all contacts, oral or written, with persons other than IRC staff, attorneys, and commissioners regarding the contract. The log shall include the name of the person, the organization the person represents, the date, and the topic addressed. This does not apply to contacts made while attending a public hearing or a meeting of the AIRC. And I'm seeing that I need to add an A to one of my IRCs in the paperwork. And so if there's other wordsmithing, we may do that, but this certainly would be the concept and the language that we have discussed.
I'm just reading through the language. If anyone has comments or questions they want to raise, feel free.
Madam Chair?
Mr. Herrera?
So Grady, explain this. So if, just to want some clarification, if somebody in the audience here wanted to speak to strategic telemetry, just any random question, Steve, for example, Muratori, wanted to call Ken, calls him up, this amendment's already in place, so you would have to log that call? I mean, I just want to make sure I understand.
Madam Chair, Commissioner Herrera, yes, if he comes up to the meeting, then we're not going to require that they, log that kind of a contact, but if they get a call at the office from any media or anyone else, those would be logged.
And a question, how does the public or anyone else have access to the log?
Madam Chair, my thinking is that this would then be a public record, and if someone wanted to request it, they could get it.
Okay. Other questions or comments on this proposed language?
Madam Chair, may I request clarification on 2 points?
Certainly.
One, the exemption for questions directed to us during public meetings, does that include public hearings as well? My understanding would be that it would. I want to clarify that.
And Madam Chair, Commissioners, Mr. Strasma, it does include, says this does not apply to contacts made while attending a public hearing or meeting of the AIRC.
Thank you.
I think we have that covered. I thought about adding your family, but I thought that would sort of go without saying that, there may be sort of other contacts that they're not logging. This is about contacts in the course of their work on this contract.
And my second point of clarification was this would be going forward. We have not been meticulously logging contacts to date, but we would begin at the time at which this amendment was adopted. And I would appreciate an exemption for my family, but happy to log those contacts if needed.
We
Okay.
can include the family exception, but I think, again, there's some common sense to how it would be implemented, and it would be going forward from the date of execution.
Other comments or questions?
Madam Chair.
Mr. Freeman?
So, Council, we need to take action as a commission right now to direct Mr. Bladine to implement these contract modifications.
Madam Chair, Commissioner Freedom, I think he has the authority to, but if you'd like to make a motion and approve it, that would certainly be fine.
Other comments or questions?
Madam Chair,
Mr. Freeman?
I certainly think these modifications are helpful. So I think we should go ahead with these. And if we need to further tweak them, it sounds like what council is saying is Mr. Bladine has that authority going forward. Correct?
Madam Chair, Commissioner Freeman, the procurement officer has the ability to execute contract amendments.
Okay. Any other comments or questions?
Madam Chair?
Mr. Herrera?
Yeah, I don't know if anybody knows the answer to this, but yeah, I don't disagree with the amendment. I think it's a good amendment, but I wanted to see if this amendment appeared in the contract for NDC 10 years ago. Was it the same? Did they have a similar amendment or wording? Does anybody know?
Madam Chair, Commissioner Herrera, I did not go back and review that, but so I don't know specifically, but since we kind of just made this up, I doubt that it was included.
Okay. Thank you.
Other comments or questions? Discussion?
I support the amendment and the direction that we're taking.
Okay. Great. And we don't need to do a motion to...
Well, if you'd like to do a motion, that might,
Okay.
that would be fine.
Madam Chair,
Ms. McNulty?
I would move that we acknowledge Mr. Bladine's authorization to amend the contract and request that he pursue that he complete that with the 2 clarifications that we've discussed here today.
I second that.
All in favor?
Aye.
Aye.
Any opposed?
Was there going to be discussion on the?
Well, I felt like we had discussed, but if we could, I'm happy to have more discussion if we would like it.
Before I vote aye, I just wanted to say that I still reserve my prior objection that the commission did not authorize Mr. Blading to enter into and execute that contract to begin with. That being said, I vote aye.
Okay. So we have the motion carried unanimously. So Mr. Blading, you'll be moving forward with that. Great. Thank you very much. So,
Madam Chair?
yes, Mr.
Point of
Sturts.
clarification, I'm abstaining from voting on this.
Oh,
'Cause
I didn't realize that. I'm sorry.
I'm abstaining from voting on this. I don't,
Okay.
so
So for the
I'm
record,
still questioning whether or not there's validity in the actual execution of the contract.
okay.
So I prefer to abstain until that issue is resolved.
Okay, so for the record, we have 4 ayes and 1 abstention with Mr. Sturts. Our next item on the agenda is item 6, discussion and possible action regarding open meeting law training for the commission with respect to communications outside of public meetings. I think in talking with council, we decided that this would probably be something we do at a later time just because of the agenda items that we have in front of us today. But I'm open to discussion. If council has something to say too, that's fine.
Madam Chair, that's correct. That's our recommendation, to not take action on this and move to the other substantive issues on the agenda.
Okay,
Agree.
okay. We'll move forward then to discussion and possible action on mapping definitions. So I think as everyone's aware, there's a number of definitions out there for things like communities of interest and how is competitiveness measured and things like that. And if you look at what the last commission did on our website, there's a link to the previous commission's work, and you can see the definitions that they ended up adopting. We heard during our public hearings when we were out across the state, some folks wanted us to define that and have this commission, do that. Others said differently. They said we should keep it open. So we thought it would be a good thing to discuss in front of everybody and come up with maybe some pros and cons of defining them now, or do we want to keep that open for later? And it would be helpful, I think, too, to know the timing of when the last commission adopted definitions and how they came to those, if anybody has that historical knowledge.
Madam Chair, members of the commission, I'll briefly give you my understanding. These definitions that are posted on the commission's website from the last commission came as a result of a court order based on the legal challenge to the lines, the legislative lines. One of the arguments was that by not having definitions, the commission had violated the Equal Protection Clause of the United States Constitution. And the Superior Court judge agreed with the challengers. As a result, the commission had come up with these definitions that still exist and are still on the website. Subsequently, on appeal, the Court of Appeals reversed that ruling by the Superior Court. But I don't believe the commission ever took any action to, do anything with the definitions at that point. But effectively, they weren't necessary, I suppose, in light of the Court of Appeals opinion, which is still good law.
When were those definitions adopted? Just ballpark estimate.
I think it was 2004.
Yeah, I think it was, that sounds, Madam Chair, members, Commissioner Herrera, I think that sounds right. I can go back and find out for sure.
But it's, I'm sorry, can you repeat it? 2004?
I believe it, because it came after the court proceedings, which I think the lawsuit was brought in late 2002. It took a while, for the court to issue its ruling, and then they had to reconvene. So that sounds right, but I hesitate to to confirm that without going back and actually looking.
Okay, any comments or questions on this topic from commissioners?
Matt. Okay. Madam Chair, members of the commission, I thought I'd just take a quick second to summarize what the Court of Appeals said in its ruling, just so you have context. It was a very lengthy opinion, and this was one of many issues addressed, but when they got to this issue, they essentially rejected the argument that the Equal Protection Clause required that there be these kinds of definitions. The court acknowledged that districting decisions require judgment, and particularly because the commission is charged with considering a number of variables that may often conflict with each other, and that the court went on to note that it's impossible to define what a perfect map is, and that the commission obviously needs some flexibility, and that the court did note that the existence of standards may aid the commission in reaching its agreement, but they do not guarantee unanimity, nor is unanimity mandated by the Constitution, since a quorum, a majority of a quorum is all that's required for this body to make decisions. The court did say, and I think it's important to note, that that the commission cannot ignore any of the constitutional criteria, favor one criteria over another. Let me make this to say, let me put this in, let me just read this exactly as it is. It says, this is not to say that the commission can ignore any of the constitutional criteria, can favor one criterion without considering the others, or can apply or interpret them in a way that no rational commission would. So they did clearly say that there obviously the commission's decision have to be rationally based, and in our opinion, in my opinion, that is based on deliberations and community input among the body itself before it makes its decisions.
Thank you.
Madam Chair?
Oh, Mr. Strasma.
If I may, this item is on the agenda for tomorrow and Monday as well, in case these issues come up again. I would recommend, regardless of whether the commission chooses to adopt official definitions or not, that at least some of them be deferred until after a presentation tomorrow, which is scheduled on public input from the first round of hearings. And many of these criteria were topics that came up frequently in those meetings. And at Monday's meeting, we have scheduled a presentation on electoral data and competitiveness, which would, I think, speak to the commission's decision on definition of competitiveness. So I would recommend not taking action on at least those two items until after those presentations.
Thank you.
Madam Chair, and we also have some folks who are here or put in slips specifically on the definitions, and so I think I saw an ASU professor, and then also Dave can tell me if Fair Trust. I don't know if there are others, but again, discretion of the chair in terms of whether we hear that public comment now or at the end of the meeting.
Look and public session. The time is 2:13 p.m. So we were in the midst of Agenda Item 7, discussion and possible action on mapping definitions. And we've gotten some public comment, actually, on a couple agenda items that I thought we could go ahead and address now, since it's an appropriate time. One is actually goes back to our last agenda item, contract modifications for strategic telemetry. We have a request to speak form from Steve Muratori, publisher of Arizona Egalitarian. So if you'd like to come up for public comment, we'll address a few of these right now.
Thank you, Madam Chairman, Commissioners. I wanted to indicate that I'm very uncomfortable with the proposed modification for the purpose of requiring the mapping consultant to log contacts with media bloggers. I understand the intent of the contract modification being to keep track of any attempts to lobby the commission or the mapping consultant, but inquiries from the media just seems like it's inappropriate. So I would hope that you would revisit that. And as a matter of fact, Commissioner Herrera noted that as a concern. And so hopefully that's something that you will give additional thought to. I also wanted to mention briefly that I'm very uncomfortable with the commission yielding to threats from a clandestine lobbying. And Fair Trust is clandestine and is a lobbying group that is addressing this commission. And it's my understanding that the risk that legal counsel was addressing really is a threat of litigation from a clandestine lobbying group to try to get you guys to do something that's going to cost more money. So I think that's incredibly inappropriate for that particular consideration to be made. That's what I got. Thanks.
Thank you. Our next speaker is Jennifer Steen, Assistant Professor at Arizona State University, and this is on mapping definitions.
Thank you, Madam Chairman. And thanks to all the commissioners. I'm an Arizonan as well as a professor, and so I really appreciate that you're doing this thankless, unglamorous, hard job. I wasn't even sure I wanted to come and testify today, so you guys show up and put yourselves on the line a lot, so thank you very much. I wanted to speak a little bit about mapping definitions. I think you should adopt them. I think that it will provide a good benchmark and sort of, that we all know there's going to be litigation. There's no doubt that there will be litigation of some kind after this is all said and done, and I think that if you can demonstrate that you're operating in good faith off of well-defined standards, that will help in that process. But assuming that you do end up adopting some definitions, I wanted to offer some comments on just a couple of them. Some of the criteria will be really quite easy to define. Equal population is not ambiguous, especially in the congressional context, right? You just don't have the latitude to define that. It's plus or minus one person. The Supreme Court's been really clear on that. There are other criteria that offer you a range of objective, numeric measures that you can employ, for example, to measure compactness. There are a variety of things like the Polsby-Popper score is one that's very well known. And so, I don't have a dog in that race, but you can choose that fairly easily amongst yourselves. The definitions of competitiveness and of communities of interest will be a little bit trickier to deal with. And with respect to competitiveness, I know you've already received a lot of comments on this. I want to add my voice to those who've urged you to consider election results as the primary basis for your competitiveness measure rather than voter registration. There's a fallacy that I've heard repeated many times as I've talked to people and listened to folks even appearing before this body, a fallacy that treats independent voters as the swing vote. And And that's not really very accurate. In fact, it's not accurate at all. Empirically, it's been really well demonstrated that the vast majority of people who identify as an independent actually lean towards one party or the other. And in fact, those folks, when they vote, are just as loyal as most partisans. And this has been documented over and over again with hard, cold data. The most prominent example in political science is a book called The Myth of the Independent Voter. That's a little bit old now, 20 years old, but that analysis has been replicated over and over and over again. And in my written comments, I've actually provided a couple of sites if you want to look into that and evaluate it for yourselves. So that would be my recommendation with respect to competitiveness, is to emphasize election results over voter registration. Defining communities of interest is really not straightforward at all. There's no numeric score that you can rely on to define a community of interest. You do have a lot of models available to you from other states and even from your predecessors here on the AIRC in 2001. Most of those definitions are very inclusive, and they recognize communities of interest that are based on shared interests in a wide variety of categories. They can be racial, ethnic, language, religious, social, cultural, you name it, kind of all but the kitchen sink. Although there is one notable exclusion, California excludes communities of interest that are based on a particular party or candidate or office holder, and so you might wish to consider whether you want to make such an exclusion. It would seem consistent with the spirit of Prop 106 to do so. Most of these definitions leave implicit the requirement that the shared interest has to have some relationship to representation or to public policy and legislation. And I think that's actually a big fault in most definitions of communities of interest. Arizona does not have that fault. Your predecessors chose to include key language in their definition, and I'd urge you to replicate that this time around. At the end of their definition of community of interest, you all have this in front of you, but they define it as a group of people in a defined geographic area with concerns about common issues, with examples, that would benefit from common representation. And I think those 6 words are really very key, right? You want to differentiate between interests of affinity and interests that relate to the matters that the folks who will be elected from these districts will consider, all right? The state of Kansas has a similar note. They recognize communities of interest where those interests are probable subjects or relate to probable subjects of legislation. And I think one reason why you might want to do this is because you're eventually going to face very difficult choices that will require you to differentiate among the variety of communities of interest who've presented themselves to you. I think that it's inevitable that you'll find conflict among communities of interest, right? They'll have different preferences, or even between the preferences of some communities of interest and the other criteria that you have to consider. And so one way that you can differentiate is by considering how central is this interest to the business of the state legislature or of the Congress, okay? And so, for example, I've seen in a number of locations, and a number of different citizens have testified about their school district constituting a community of interest. That seems quite compelling to me because it's a very well-defined geographic area, but you also know that the families who send their children to the same schools are similarly affected by state policy and state funding for education, right? So that's unambiguously related to politics. We've heard other groups who talked about feeling a strong sense of community, but in kind of vague terms. They feel a strong affinity with their neighbors, but they don't ever describe how that relates to their ability to be represented in the legislature or in the congressional delegation. So I think claims like that should be considered. They've presented themselves as communities of interest, but where they come into conflict with other interests that are more clearly related to government activity, or where they come into conflict with the other constitutionally mandated criteria, I don't think they should be favored, and so I would urge you to consider that. One last thing is I also want to speak about the definition of significant detriment in the context of communities of interest. Of course, you have to determine the degree to which you can create competitive districts without causing significant detriment to the other criteria. And again, this is, it's very difficult, but what I'd urge you to do when you're considering how to evaluate the detriment, the level of detriment to communities of interest, is to consider them as a whole or as a collective, right? Not consider them serially. Don't say, oh, is there a significant detriment to this community of interest? Oh, well, yes or no. Is there a significant detriment to this community of interest? You want to look at the big picture. Ask yourself questions like, how many communities of interest have presented themselves to us, have self-identified? How many of those interests can we accommodate? How many of them have inherent conflicts with the other criteria, whether it's the existing geographic features or natural boundaries, the Voting Rights Act, et cetera. Think about the degree to which communities of interest in general are affected by modifications to the map to create competitive districts, rather than going one by one through each community of interest. Because of course, if a single community of interest has their representation diminished by competitiveness, that group is naturally going to feel like that's a significant detriment. But if it's one group out of dozens or hundreds that present themselves, that may be tolerable. And in fact, I would argue that it is tolerable because we all recognize that there's no way you can perfectly accommodate all 6 of the criteria that you're charged with. And of course, the framers of Prop 106 recognize that as well, which is why they put in to the extent practicable, right? That qualifies every single one of those criteria. So we know that we have to tolerate some imperfections. Not everybody can get everything that they want. So when you're considering the possibility of significant detriment to communities of interest, keep that in mind, that it's not fair to have perfect, everybody who asked for it gets it, as a standard to compare modified maps to. And with that, I thank you. Any questions? I'm used to taking questions.
I don't know if we can.
I'm also used to talking for 80 minutes, so thank you.
Okay, thank you. Our next speaker on this same issue, definitions, is David Cantelmi, Fair Trust in Cave Creek.
Madam Chairman, members of the Commission, thank you again for the opportunity to speak to you. I very much appreciate the way you're doing this in an open way. I would join with Professor Steen in urging you to adopt definitions. I've been urging the Commission to do that one way or another since 2002 or 2003. I also would urge you, before you adopt any particular definitions, to publish the proposed definitions on your website so that you can get public input. I don't today offer any specific or particular definition, but I do urge a process, and that process be open, and it give notice to the public, and that you do indeed adopt definitions. And the reason for adopting definitions is because it assists the Commission in performing its work in a reasoned and impartial fashion. Now, it's likely that you're not going to please everybody. Nobody ever does. But it's important for everyone to feel that the process is fair. And if you have definitions and they are reasoned and they're uniformly applied, or if not applied with reasoned distinctions, then that supports your work product. It supports public trust in what you've done. And I think it's the better way to do it, and I would recommend it to you very highly. Thank you so much for the opportunity to speak.
I think that's all from my request to speak forms that are relating to that topic. Just checking. Okay. And
Madam Chair,
yes, Ms. McNulty.
are we, may I make a comment on the definition question, or are we done with discussion of that issue until the next agenda?
We haven't left that agenda item yet, so if people have other thoughts, sounds like it is on our agenda for the next couple of meetings, both tomorrow and Monday. But if people have other thoughts that they'd like to raise now, they're welcome to.
I think I'll reserve my specific thoughts about these two issues for our other meetings, but generally speaking, I believe that it's important that we each as commissioners have clear thoughts about each of the concepts and how we're going to be evaluating, and that we articulate those in the process of making our decisions on the mapping. whether we can all, as a commission, reach agreement on a definition of competitiveness and/or communities of interest is another question, and we may be able to do that. However, if we are not, I think it is equally important that we each as individuals have well-reasoned thoughts about how we approach each of those criteria and can explain those as we go forward with respect. My mic just went out. These mics are so touchy everywhere we go. I also think that it makes sense for us to have discussion, perhaps about thoughts about the criteria as distinct from coming up with a hard and fast definition, because at the end of the day, I really think each of these things is going to be kind of case by case, sort of a tailored to each particular situation. So I think that we as a commission will all benefit greatly from talking with one another and probably with our mapping consultants and with our lawyers about the various factors that we would think about that would go into definitions. But at the end of the day, we may all wind up having slightly different thoughts about what each of these things mean, and I think that would be consistent with both the Constitution and with the case law on the Constitution, as long as we exercise those in a reasonable and rational way.
Thank you. Other thoughts from other commissioners on this item?
Madam Chair,
Mr. Freeman.
I definitely need the microphone. I agree with Commissioner McNulty to the extent that I think this is the first step. Whether we adopt definitions or not, I think we've posed this issue to the public during our public comment sessions. This is the first time it's really been teed up on our agenda. I know Council's recommendation is that we not adopt definitions today. That's I know Mr. Strassman also wants to talk with us, and I certainly agree with that. I think it does not make sense for us to take too many steps down that road today, because we don't want to define ourselves into a potentially a box, which is why it's important to hear from Council and our mapping consultant and from the public as well. And I think we'll probably get a lot more comments from the public, maybe at the end of today's hearing, maybe tomorrow, and maybe again on Monday. And I agree with Commissioner McNulty. The commissioners really should put pen to paper and formulate some definitions, if that's the road we're going to take, and be able to articulate them and discuss them publicly and put them out to the public so the public can comment upon what we come up with.
Thank you. Other comments from other commissioners? Okay, good discussion. Thanks, everyone. And thank you to the public for your comments on that as well. Our next agenda item, authorization of second round public hearing general locations. It's item 8. We all received a draft of what that might look like from our Deputy Executive Director, Christina Gomez. I'm not sure.
We're hiding right in front of you.
You're right in front of me. I was looking for you there. Okay, sorry. So if you wouldn't mind telling us about the memo and giving us an intro to the second round, that would be great.
Okay. So we just finished with the first round of public hearings, and the first round of public hearings really is an educational piece for the public to learn more about redistricting in general, and for the commission to also become more aware of the different cities and towns and regions within the entire state. So our next step is the second round. And the second round of public hearings really consists of a critique of a draft legislative and congressional map. So how I went about creating this schedule is I actually went through the 2010 census redistricting data. I looked at the most populated cities and towns. And then I also looked at heavy populated or a high concentration of minority groups within these cities and towns as well. We did try the remote locations during the first round of public hearings, and it actually worked out pretty well in certain cities. However, in more rural part of our state, the Skyping system really didn't work for us. So when I was thinking of this schedule, I contacted a few community colleges, and they do have video conferencing available. However, the issue that I came across was school has just started, so a lot of these classrooms are taken. These classrooms can hold between 30 to 40 people, which is kind of small, considering the second round of public hearings will probably be a higher attendance, given that people will have a map to comment on. So that was the other issue that I faced there. So I did make a few phone calls, though, and specifically with the City of Flagstaff, I did contact Coconino Community College. They are able to host us during the week of September 18th. However, with school starting, they can't accommodate a video conferencing connection between Tuba City and Page. So during this second round of public hearings as well, this is the time where we will see a greater increase in public comment. So staff will be extremely busy receiving and recording and sending out this public comments back out to you all. And we do have a system that we are working with, and I believe Mr. Bladine and Mrs. O'Grady will be talking about this later on. But second round is, the volume is very, very high there with public comments input. And we are also recommending that the public hearings for the second round take place in the evening hours as well, weekdays after 6 o'clock from 6 to 9 p.m., and then weekends from 1 to 4 p.m., and that would be on a Saturday. And you have also received a list of cities and towns, and the public has as well.
Great, and this is a draft, but I know you're hoping to get some sort of authorization to move forward, right, on some of this? Okay. So did commissioners have a chance to review the memo and also the attachment showing the list of second round public hearings potential? And any comments or questions?
Madam Chair?
No? Yes, Mr. Herrero?
Is the goal before the start of these second round hearings to have an initial draft map for the first draft?
Yes.
Thank you.
Madam Chair.
Mr. Freeman?
Ms. Gomez, I was pleased to see that we've got a few more rural areas on the list, and a few of the other areas I had suggested for the round one is, so it's my understanding that we would not attempt the satellite tie-in for round two, correct?
We will try. However, I don't want to put down cities just yet, because I would hate to go back like the last time and give some bad news to folks that we're not able to video conference them in. So.
But I guess we're covering a lot more ground here, but there's the option if someone were to speak up and say, look, there's an urgent need, we could maybe tie it to one that's currently on this list and make the attempt.
That's up to you all.
And is this the proposed order we would go in?
I just put them in this order just to make sure I was covering every city and town that I could possibly, that I wrote out during my draft. So I looked at the map. I went down to I went through my redistricting U.S. Census data sheet, and I just wanted to make sure that I was keeping track of cities and towns. So this was mostly for me, really.
And I know we've heard throughout this process from certain groups, organizations, and tribes that they're going to be meeting and formulating responses and comments to the commission. Are we taking that into consideration as we put the schedule together so that if someone was meeting later in September, we don't put them too early, so we don't give them an opportunity to meet, bring their concerns to us?
Madam Chair, Commissioner Freeman, when Christina was developing the schedule, we talked about the best we can do is give you what we think's in order, but as you're bringing up, as we started to implement round 2, we had requests, can I go later, can I go earlier? We have a conflict in the city council meeting that day, so we would look at this as a draft, hoping you would approve us moving in this direction with the understanding it very well could change in order so that we could accommodate the things you're bringing up.
Okay, thank you.
Ms. Gomez? Does the community college system not have a central location where we could stream a meeting to all of their other locations?
I could look into that.
One thought that I had was that if we could, if we began our second round of hearings with something like that, which wasn't necessarily interactive at every location, but provided the maps to people and gave them an opportunity to, hear what the presentation is and hear what the public comment is at the location where the maps are being presented, that might be helpful for people in deciding whether they wanted to attend a location, a live location. Just a thought. So I guess I would ask that we at least look into that and consider that. My other comment is that I want to be careful that we don't lock ourselves into a time frame or an order or a schedule that we cannot ultimately meet, and therefore we disappoint people. I think we have a lot of work to do. It's already August 16th. We need to do a good job on these maps. That's first and foremost. If we get to September 18th and we aren't ready or we haven't done a good job, no one is going to say, well, that's, we understand because you were trying to do a good job. I'd rather that we make sure before we start nailing down dates that it's something that we can actually accomplish. Having said that, I understand that you need to start looking at venues and so forth, and I think that's great, and the list looks good to me, although I'm certainly open to comments from my fellow commissioners about where we go and when. But I'd like, on the one hand, to begin the process of getting things queued up, but on the other hand, not commit to something that either results in us not being able to meet it or not being able to do the work we need to do in the next 4 weeks, not be able to complete the work that we need to do before we start this round.
Madam Chair, Commissioner McNulty, we, being the legal staff and the mapping staff, discussed that very issue this morning as to the starting time of the 18th. And we felt that's really the drop dead date that we'd have to have an adopted map so we could go out. And we felt pretty comfortable that we could make that. It, of course, depends on us putting a lot of pressure on you for a number of meetings over the next several weeks. But we do believe that the 18th is a reasonable time to start round 2. And perhaps Ken or Joe or Linda would like to comment, but we were concerned just about what you're saying. We didn't want to start out and then find out we couldn't meet it.
Yeah, I feel pretty strongly about that, and although I really appreciate all of your optimism, we're the ones who are going to be driving that boat, and maybe we will accomplish it, but I think we need to be prudent about it. for the reasons I described.
Thank you, Ms. McNulty. Comments, questions from other commissioners on the schedule or the memo?
Madam Chair,
Mr. Sturts?
Ms. Floydine, Ms. Gomez, obviously the Septembers are not meant to say Septembers if we're not starting until the 18th, being the most optimistic date. I concur completely with Commissioner McNulty that we've got to set a target date for ourselves. The deadlines are always important. But we also have to realize that as we get closer to that date, I don't have any intention to compromise what we would be putting out in our first draft in an effort to distribute. So I would like to hear a comment back from that. Second is that obviously these are going to be running into the month of October. There's 22 dates. That you've got listed out here, 22 different locations. I'm also going to suggest that you cluster for the purposes of staff and legal counsel and commissioners, that you try to cluster these into parts of the state. The last go-round, I know that you needed to make adjustments based on availability of sites, but there were dates where you were in southern Arizona, northern Arizona, southern Arizona, northern Arizona in 4 days in a row, and that put an enormous amount of stress on staff and legal counsel, as well as on the commission. So as you're taking these things into consideration, we realize and recognize that there are deadlines and there are priorities involved. We do need to set a date that we're gonna sort of pull the trigger, and I think as commissioners, we should just we're gonna have to sort of self-apply a date, because there's gonna have to be a date for staff to be able to begin locking down locations, because that's what your critical issue is right now.
Yes, sir.
Okay, thank you.
Other comments, questions?
A location, Bullhead City. I recall when we were there, people were asking us if next time we were going to meet in Lake Havasu City. Is that a facilities issue? And I think perhaps we had commented that although we went to Bullhead City for the first round, we might go to Lake Havasu for the second round.
We can do that.
I mean, we may just want to consider that, because I think it was something that had been raised.
Along those lines, I had a comment too on location. I noticed on some of these you have 2 towns listed, either or, and then some are listed with a slash, which I assume is also a choice between 2 locations. And I was wondering on Globe, forgive my Arizona geography, I'm not sure how far that is from Payson, but Payson is another town that was mentioned at some of these public hearings as one that we might want to consider for the second round.
Madam Chair, we can put that down as well.
Okay, great. And each of these locations, we will be able to stream from, right? We can at least do the video, a streaming of the meeting on the internet, or no? Not necessarily.
Madam Chair, the other problem that we had with some meeting facilities was internet connection. So it depends on what type of connection they have.
Okay.
And we usually we didn't know until we actually arrived and started to stream to actually know if it would work or not. And also to your question regarding, for example, the Marana or Oro Valley, I just left that up to you all because I wasn't sure which town you would like to visit there, so.
Okay, yeah, in Sahuarita or Green Valley.
My thought would be it would depend on the availability of a facility, because they're very close to one another. That's right.
Madam Chair, I think that is what Christina was just saying. Our goal is to try to find locations that stream, and we found last time that what we thought would work wouldn't necessarily, but we'd still try to find the streaming. And we also found last time cities we thought would work didn't work, but a neighboring city would work, and that was like Lake Havasu and Bullhead. So we just want you to be aware that for us to actually implement it, we may have to have that kind of flexibility, but our goals will still be the same, to maximize the streaming and get to the cities we first lay out.
Okay.
Madam Chair?
Mr. Herrera?
I attended a good chunk of the meetings during the first round, and obviously it was pretty obvious to me and to the rest of the commissioners that attended these meetings that the staff was stretched pretty thin, making this is 15 meetings, and we're adding 22, I think 23 with Payson, and we decided to do that. That seems, unless we hire more staff, and I see that it could be problematic. I mean, 'cause let's be honest, like I said, it was tough. I mean, Buck, I think, attended most of them. These are only IT on staff, and are we going to require them to attend every meeting? That's 23, include Payson. So I want to be, although like I said, this is probably my favorite part is going to these meetings and listening to the public comment, but I want to be fair to the staff and the commission as well, that this is truly reasonable and doable. Because last time we ended up canceling some of the towns that we had promised, and I know some commissioners were not happy with that, and I don't want that to happen.
Good comment. Well, I do look to Mr. Bladine to let us know about staffing, and I know we have 3 public outreach coordinators who've been helping. But if we look to you to give us that recommendation as to if you think you need more staff.
Madam Chairman, Christina and I have talked about how we can accomplish this, and we don't have a definitive answer for you, but probably our biggest issue is the streaming and recording. We have $1. We have talked about the possibility, as you recall, we had a few places last time where they could do the recording for us and the streaming. We'll try to see if there's more places so that we can not have all of this fall on Buck. We've also talked about the possibility of exploring hiring a service that might do 1 or 2 of these, and perhaps the ability to even do 2 on one day. So we're not prepared to answer how we're going to do it, but we do understand it will be a challenge for us to get this done, and we're going to look for alternative ways to bring it about. And it seems to Christina and I, when we talked about it, that the big issue will be handling the recording and the streaming. We probably have enough staff to cover several locations. If you're all willing to, do on perhaps one day 2 different locations. So we'll bring you back more detail once we've started to see what we can do.
Madam Chair,
Ms. McNulty, sorry.
fellow commissioners, I've just looked at a calendar, and I would suggest that September 26th, which is the Monday after September 18th is a Sunday, the following Monday is September 26th. To me, feels like a more realistic target date. So I'd throw that out there for comment.
The week of September 26th.
Yes. So that Christina could begin looking at locations, seeing what availability is out there, maybe coming up with a plan for grouping cities and towns geographically, looking at what alternatives might be. And while she's doing that preliminary work, we can be working with the mapping consultant about what our trajectory is going to be, and get a little better sense of what the timing is going to be before we actually start noticing things.
Madam Chairman, obviously from the staff perspective, for setting the second round, more time is better, easier for us. But I would also raise the issue that it'll put more pressure on the tail end in terms of getting the maps adopted after the hearing, if our goal is October 31st. So if we do that, I think we need to make sure the mapping consultants told us how that would affect them if we went back. The 18th was based upon their schedule, and I'm not saying we should stay to the 18th, but I think we need to recognize if we move back, it may have an effect on when we'll get the adopted plan.
I understand that, Mr. Bladine, but the maps are what this whole exercise is about, and we need to have the time to do that job properly.
Madam Chair?
Mr. Sturts?
Starting on the 26th, leading up to the 26th or 27th of October, that's 30 days, of which I think we can fit 23 including Saturdays, we can fit 23 meetings into. So the target would be if we started on the 26th, that we can fit 23 days in those 30 working days. So I concur with Commissioner McNulty. That gives us a deadline and you a starting place. I think what Commissioner McNulty was looking for is we're looking as a commission for another week window so that we can flesh out the issues, so that what we're doing out to the public has actually been drilled down to something other than something that we really have worked through. So.
Thank you. Other thoughts?
Madam Chair?
Mr. Herrera?
Although I don't disagree with Commissioner McNulty, my only concern is with pushing the date to the week of September 26th. Is that, what does that mean? So we will have a full month of doing public comment and then wrapping up late October, and then having a few days to compile that and get that information along with other criteria and other information and put together a map. That doesn't seem like it gives us enough time to do that. I think we'll be, I agree with Mr. Bladeen that, yes, we'll be allowing more time for us to create that initial map, but at the end, I think we'll be running out of time to create that map that we need to create. So I'm a little cautious.
Mr. Strasma, would you like to comment on the timeline?
Thank you, Madam Chair. The timeline starting on the 18th would allow for roughly 2 weeks at the end of the 30. I'll begin again. The timeline starting at the 18th would allow roughly 2 weeks at the completion of the 30-day public comment period for adjustments based on the public comment and adoption of the final plan in order to make the deadline of October 31st. Moving it back changes that to 1 week. So it is still doable, and I've told a number of commissioners that I will speak up if ever there are changes to the timeline that make it impossible to meet the deadline of the 31st. Basically, this is a question of, do we want to spend more time on the first draft map that goes out to the public at the expense of having less time to make adjustments based on the public comment? It is still doable to make the 31st, but it would mean an intense week of meetings and adjustments the final week of October.
Thank you.
Madam Chair?
Mr. Sturts?
Is there anything that would preclude adjustments being made during the 30-day process?
And that's direction that we would seek from the commission. We did discuss that this morning. I know there's been discussion of what-if scenarios, like if there's public input during the 30-day period about can you try this, and commissioners were to come to us and say, can you see what the implication of this change is? That's certainly the sort of thing we can be working on doing the 30-day comment period and expect to be. I imagine, well, it's a decision for the commission. But my guess would be that the commission would choose not to give actual direction as to the map until all communities had been heard in the 30-day comment period. But as recurring themes come up, we can definitely be working through the what-if scenarios. So it's not like we would have to be, wait to start adjustments until the end of the 30 days.
Madam Chair?
Mr. Herrera?
We had talked when we had hired Telemetry, and they provided us the timeline that we want them to meet that timeline, and we want to do everything we can to help them meet that timeline. So moving the date to the 26th really is not going to be beneficial, I don't think. So I would propose that we keep the 18th. That's what they're recommending. Give the public enough time to make their comments. It would be unfair for us to be making changes at the beginning of the public comments when we have maybe City of Yuma at the end. Maybe they'll feel a little left out. You've already created the map without our input, so I would not be in favor of that happening. So I would prefer that we keep the date as they recommended. We're sticking with that timeline that they proposed, and I want to make sure that we help them out.
Thank you. Mr. Canfield?
Madam Chair, members of the commission, I'm just looking at the constitutional language. And we may need to look at this a little more carefully, but as I read it, what the Constitution envisions is a map is finalized and then advertised or put out for public comment for a period of at least 30 days. If during that period the map has changed, we'll have to analyze whether or not that would reset the 30-day period, and that's kind of what the timeline you're operating on is the 30-day period with changes at the end of that.
Good point, thank you.
Madam Chair?
Mr. Sturts?
Mr. Strassman, now that we've given the green light to purchase the online mapping for the public access to it, when will that be implemented?
We expect that will be available within 3 weeks.
Okay. So 3 weeks would put us at the week prior to the 18th?
Yes.
Okay. So that would give essentially 1 week for the public to start to look at the grid maps.
Correct.
Okay. What I'm driving at is I want to give as much opportunity for the review of the grid maps and for the much opportunity for the public to get an understanding of the Maptitude software so that they can, because our goal is that during the 30-day period of collection of data, is that the public is going to be reviewing the map that we're going to be distributing and be giving comment, as which you're going to be cataloging that comment during that time frame. Is that correct?
That is correct.
Okay. So my hope is that, and all due respect to Mr. Herrera's time frame, it'd be great to give the public the opportunity to fully vet the software that'll be online and then fully vet and participate during the process. So I'm gonna stick with the start date of the 26th. I think we can make it work, and I think if we're able to compress it on our end, on the front end, I don't think that that's changing the process of getting the information out to the public. And lastly, and I'll close with this, that it's really incumbent upon staff to be able to, and I think that it was mentioned by Mr. Bladine and Ms. Gomez, that having two-a-days I don't think is going to hurt anyone's feelings. If we're going to do Oro Valley in the morning and South Tucson in the afternoon, I don't think that that's going to bother anybody. The more that you can be efficient with your time, your scheduling, and the public's, and the dynamic of the public, I'm sure that you can be smart in finding locations that are going to be able to accommodate that as well.
Thank you. Other comments, questions?
Mr. Canfield, could you read that language one more time? Is it are we advertising the final map? Is that what I heard you say, or the initial, or?
Madam Chair, Commissioner McNulty, I'm reading paragraph 16 from the Proposition 106. It says the Independent Redistricting Commission shall advertise a draft map of congressional districts and a draft map of legislative districts to the public for comment, which comment shall be taken for at least 30 days. Either or both bodies of the legislature may act within this period to make recommendations to the commission by memorial or minority report, which recommendation shall be considered by the commission. The commission shall then establish district boundaries.
Thank you.
Madam
Ms.
Chair?
O'Grady? Oh, sorry.
Mr. Canfield, does that preclude creating working analysis during the course of the 30-day period by the commission?
Madam Chair, Commissioner Sturts, I don't believe so. I think the map that's being advertised is the map that's being out for public comment. So certainly this process envisions that during that period, you will not only receive public comment, but I'm sure the commissioners themselves may have some thoughts and ideas on how that map may be adjusted at the end of the period. The question is whether what I understood is, could a change, maybe I misunderstood. If a change was made and the commission adopted it in that period, well then arguably it would reset the 30-day time period. But I don't believe there's anything that would preclude the commissioners individually working with the consultant based on public input from making proposed changes and during that process that would ultimately be considered at the end of the 30-day public comment period.
Yeah, Madam Chair, Mr. Canfield, yes, I had no intention of coming up with the idea that we would be re-ratifying or ratifying a new draft map for publication. This would be just a time when the commission would be able to analyze the information almost on a daily basis at our will. We're all being provided with the software, we're all being provided with the maps, and as Commissioner McNulty had inferred, we are all going to have our own personal baseline of criteria of which we're going to be making some decisions on, and we'll be able to drill down some of those thoughts and see whether or not they're functional as we get the public comment during that 30-day period. I had no intention of reissuing a new draft. So, hope that clarifies.
Thank you. Ms. O'Grady?
Just one point, Madam Chair, Commissioners, in terms of the October 31st date, we required in the contract amendments a schedule that would permit completion by October 31st. And so that's the timeline that's been developed. I think we all knew, and that Strategic has been and is prepared to meet. But obviously, if the commission in the process decides that they'd like to go beyond the 31st in order to do the kind of job that they think, you know, to take the time that's necessary to do the job, they can do that, that you can do that. We were also in developing the 31st deadline, taking into consideration the comments that we received from election officials from Maricopa County, which was they're looking at their December 1st deadlines as far as local precincts and that sort of thing. But there is some real-world fluidity in terms of the completion date. I just wanted to make that point.
Thank you. So I guess, is there some middle ground where we start midweek?
Madam Chair, does this require a motion?
I think it probably would be good to do a motion and, you know, to authorize Christina to at least be able to move forward with the draft agenda, given the things we talked about, just the potential changes and edits to it, just so that she can begin to start putting something together.
Then, Madam Chair, I move to...
Madam Chair, before we vote, can I make a quick comment? I mean, just I want to make sure that we go back to what the commitment we made to strategic telemetry, that we would be helping them meet that timeline. Pushing the date back to the 26th is not helping them meet that timeline. And like I said, I think we can do it by the date they proposed. We would just have to sacrifice our time and meet as often as we could, and develop a map by that timeline, and then start the public comments on the 18th. Like I said, if we want to stick to that timeline, which I do, I think we all agreed that that was a reasonable timeline. Let's respect Mr. Strasma and his comments, and let's go with the timeline that they recommended.
Madam Chair.
Mr. Freeman?
First of all, nobody agreed to the timeline. That was something that was a product of the contract negotiations that Mr. Bladine entered into with strategic telemetry, or negotiated with strategic telemetry. My question for Mr. Bladine and Ms. Gomez is, how much lead time do the locations typically need from us? Probably the more lead time, the better, but you know, a couple weeks before we need to really decide?
I guess I'll let Christina answer in more detail. I think to a certain extent, we kind of know some things we won't go back to, and some things we will, so that'll probably make it a little easier. But it seems to me it takes about a week to really firm up 3 or 4 locations by the time you do calls back and forth. So that's the kind of, there is an awful lot of trying to work with the community, working with the facility. So it seems to me if we, in a week, we do 3 or 4, then it may pick up after that. Let me just also make a comment that relates to timing. Clearly, you all need to decide where you want to put your time, and whether you think it's going to be more necessary at the front end or more necessary at the back. And as Commissioner Freeman pointed out, this was what we contractually said we would do, and it would meet an end. But the hard part for all of us is we really don't know how long it's going to take for all of you to come up with that first map. And I'm hearing, let's caution on the side of not being forced into a hearing before we're ready. We kind of thought we did that, but I'm not sitting up there with all of you, so you have probably a better sense of what you're going to need to go through. So I guess all I'm saying is whatever you decide, we'll work very hard to make that happen. But getting some direction today will help us a lot in moving forward with the administrative end. And finally, the chairman a minute ago said, is there a compromise? Perhaps we could start the Thursday or Friday before the 26th. But that, you know, again, you may need that for mapping. So now that I've opened my mouth about it, I really think it's your all decision, and we'll do our best to make it happen.
Thank you.
Madam Chair, I would be concerned about committing to starting midweek. I mean, when we get there, we may need Thursday, Friday, Saturday, Sunday. We may be doing what the last commission did. We may be at the Holiday Inn in Casa Grande for a week straight or 2 weeks straight. I don't know. But, it's taken us till, what is today, August 17th, to get where we are. And now we're talking about doing our maps in 4 weeks. I feel very strongly that we need to approach this with prudence, and the date I would be comfortable with is tentatively September 26th. I think we are committed to the Arizona Constitution. That takes precedence over what we committed strategic telemetry to in their contract, and I think it's great that they're willing to, bust their chops to be there for us when we need them, but that doesn't mean that we have to shorten what we need to do in order to meet that deadline. We need to do our jobs.
Thank you. Other comments, discussion?
Madam Chair,
Mr. Sturts?
I move that we set a schedule for a second round of hearings beginning on September 26th to take place in an orderly and organized fashion, whereas we try to combine cities and parts of the state so that in the best possible fashion. We do so in such a way as to not embroil the staff or the consultants in an overly aggressive schedule that does not allow us to properly meet our objectives, which are to be alert and fair with all of the public, and that we, as a part of this motion, I want to make that these dates need to get up and published to the general public in significant advance so that they can have full participation and knowledge of what's forthcoming and what the expectations are of the public at these meetings. And that if an extension or a contemplation of an extension may be required to a date, to strategic telemetry, that can be contemplated at a later date in regards to their end date.
Is there a second?
Madam Chair,
Mr. Freeman?
I had a question for council. Agenda item 7 reads, or excuse me, 8 reads, authorization of second round public hearing general location. Can the commission take action as proposed, or what does that mean in terms of what we need to do?
Madam Chair, Commissioner Friedman, you make a good point in terms of the language of this particular agenda item, so perhaps we defer that particular motion until a later meeting. And I think staff's gotten the direction that they need to proceed, so perhaps we don't make a formal motion in terms of today, since this is focused on general locations rather than the date at which the meetings begin and some of the other issues related to that.
And I hate to scuttle such a well-stated note.
It's the attorney in you. Thank you for noticing that, Mr. Freeman. Sorry?
Marty's got it down.
Exactly. Okay, well, given all that, thanks for the discussion. Is there anything else anyone wanted to bring up on this second round of public hearings? Okay, I'd like to thank Christina for her hard work on putting this together in the memo. Thank you for being prepared for us today, and hopefully you have the authorization to move forward as you heard our discussion today.
Thank you.
Thanks. Okay, it's now, the time is 3:12 p.m. and I'm being asked if we could take a 5-minute recess. So we'll go ahead and do that and enter back into public session very shortly. It's 3:12 p.m. Okay, we'll enter back into public session. The time is 3:26 p.m. And I think we've concluded agenda item 8. Moving on to agenda item 9, discussion and possible action regarding the approval of catalyst contract. I don't know who is leading this discussion. Is that legal counsel?
Madam Chair, Commission, yeah, I can get this started. This is really just an online discovery tool, database for the lawyers, so that we'll have access to the searchable data that Strategic is working on coding. And so Catalyst is an e-discovery company, and we're working with On Target Litigation Solutions. So we'll be entering a subcontract that will provide both Joe and I access to what we need to do the electronic submission to the Department of Justice. And the idea is it'll be cost savings because we'll only have to do this once in terms of entering getting access to a database that Strategic will have access to, and we'll have access to, and staff will have access to. So I don't have the subcontract, and again, the procurement officer, Ray Bladine, does have authority under the contract to approve subcontracts, but we just wanted to advise, and it's been mentioned before, so we just wanted to advise the commission that we were moving forward with this work.
So is the idea you're not looking for action from us today on this?
Madam Chair, I don't think specific, no, I would not be, just so you all understand that we're moving forward, and we'll get the subcontract in place under Mr. Bladine's authority as procurement officer.
Okay, does anyone have any questions or comments?
Madam Chair?
Mr. Sturts?
Ms. O'Grady, the name of the company is?
The actual software is called Catalyst, and
How's that
the
spelled?
website, if you're interested in information, it's CATALYST is the name of the software. And there's information on the software at catalystsecure.com.
So that's CATALYST.
And then secure.com.
Secure, SECURE.com.
So that's the software, and then we'll be working with an e-discovery vendor who will host this. So we've been working on this on quite some time with staff and looked at a number of options, and then Strategic also, and to develop something that would work for everyone and hopefully save some staff time while Strategic does what they need to do, and then give Joe Canfield and I the access to the documents that we need to do, and not have not have to be processing these documents downstream more than once.
Is this a document type of a SkyDrive sort of approach? Is it a central locator of documents? Trying to determine what the
I think I'll defer to some technical people who will. I have this, electronic filing cabinet is the way I view it.
Okay.
Search from that Andrew and Ken made.
Madam Chair, Commissioner Sturts, this is a document. It's a cloud server where all the documents from the commission, anything that's been submitted, whether it's been a web submission, mail, all information that's been presented at public hearings and handed in at public hearings, all this information will be there along with the transcripts. We have the ability to put up all media articles on there, so it's really a one-stop for place. And the only thing I would add to Ms. O'Grady is that the commissioners as well will have access to this, and if there's they will have a login, and we will go through a training to show you how you can do searches. So if you're thinking of a meeting back in March and remember somebody that had commented, you can do an easy search, and that should pop right up in terms of what you're looking for.
So there are many different companies out there that provide this type of online file cabinets type of, there's Basecamp, there's other types. Catalyst Secure is one that has been typically used by legal counsel. Is that a
Yes, it was a recommendation from, I think, your law firm, Ms. O'Grady, was the original one who had looked at a number of different databases and felt that.
Madam Chairman?
Mr. Bladine?
Perhaps I can just give some background. What we really did was early on, as we mentioned to you, we would have a tracking system for public comment. In the early versions you saw were spreadsheets that Christina prepared that documented what came in and we sent out to you. At the same time we were looking at a system for staff to do that. We realized that the legal part would need a similar sort of system, but more designed around retrieving documents for submissions to the Department of Justice, and if there were future litigation. We also realized in the contract with Strategic there was certain information they would provide. So over the series of the last probably month and a half, we've had internal meetings to look at what looked like the best approach to do this that would give everybody what they need. Our concern primarily being to provide information to you that you would have available that's searchable for the input coming in on the mapping hearings, the legal staff having the documentation already prepared so they wouldn't be pulling it together when they needed to make their filings with the Justice Department, and then coordinating with Strategic so they would keep some of the documents, the maps, in their activity, but other documents they'd ship into this, including copies of the transcripts. We'd have it all in place. We started out by taking a look at a system that was not aimed towards legal, but was more aimed towards our desires in terms of just gathering data, and realized that there was a legal system out there, and relied upon the expertise of Osborne Maladon's IT staff in working with Buck to come up with. We thought the best thing to do would be to arrange for that system through Osborne Maladon, but because we'd only talked to you about this in bits and pieces, we thought we should bring it forward and make sure that everybody understands what we're proposing to do.
Madam Chair?
Mr. Sturts?
And this is a question for either Ms. O'Grady or Mr. Bladine. We are buying a license. Is this an online service that we are procuring? Is it, are we purchasing it by space? How much space that we'll be utilizing? And if it's Osborne Maladon, who will be the owner of the license for the use access?
My understanding, and you're getting into some detail that I'm not prepared to answer in terms of the space, I can tell you that the way it would work is basically we lease the program, and then we're responsible for the data input. The cost of managing that streaming, we're not sure, but it could be from $5,000 to perhaps $20,000. So
over the term of the life of the commission.
That's right.
Okay.
Now, I would believe that since we would be purchasing it as a part of the legal contract, it would be available to us. It would be our license, but I don't know the answer to that, Commissioner Sturts.
And Madam Chair, Commissioner Sturts, I'll follow up with you. I don't have that precise language, but I'm happy to follow up.
Okay, thanks.
Are there comments or questions? Ms. McNulty?
Just so I understand correctly, the information that would be in this cloud would be commission information, and it would be available to the commissioners and legal staff and consultants, but it would not be available to third parties for any purpose unrelated to commission business. Is that correct?
I would, that would be my understanding of how these documents would be handled under the open meeting law, but yes, that.
So these are all documents that are public documents anyway.
Right.
That would be in this cloud. And
Right.
it's really for the purpose of allowing us more efficient access to the information so that we can get at the public comments, for example, when we remember something that we want to bring up as we're doing the mapping, and so that Osborne Maladon and Ballard Spar can use the information more efficiently to prepare the pre-clearance submittal. Is that right? But it's not going to be for use by the consultant in any other venue or for any other purpose whatsoever. And even if it were, it's all public anyway and on our website.
Madam Chair, Commissioner McNulty, I think you did a better job of explaining what it'll do than I did, but you're right.
Well,
It's to make
only
it.
because I
Listen.
listened to you.
Well, thank you.
Other questions or comments?
Madam Chair,
Mr. Freeman?
and Mr. Bladian, there will be a portal that will be available to us. We can log on online, and then we would have access to this database.
Yes, that's correct.
Okay. And then my question for Mr. Canfield is, do you have any experience with this software package, basically? And
Madam Chair, Commissioner Freeman, I don't. I've looked at it. It's been shown to me. If it works as it's been demonstrated, it will be fabulous to deal with and work with. So, but I have not myself used it, and I'm not sure if our firm has. I can check, but like I said, I think in the format that I was shown, it would be very helpful, and I think it would be very easy for us to use.
Other questions or comments? So will this will be an agenda item for later, or how are we going to proceed in terms of answering everyone's questions?
Well, Madam Chair, we will execute a subcontract to our contract and work with Ray Blading to get that done, and I don't see this coming back as an agenda item. If I can follow up with Commissioner Sturts on his technical questions, and if there are other technical questions, we'll do so, but I don't see it coming back as another policy to the Commission.
Okay, thank you. Any other discussion on this? Okay. Hearing none, we move to agenda item 10. We have a consent agenda in front of us. There's numerous sets of meeting minutes that you all should have received from Anna Garcia, I believe, July 26th. She sent out all of those. And we had this on a previous agenda, but unfortunately just ran out of time. So if there's no objection, the consent agenda will be adopted. Is there any discussion?
Madam Chair, I do have a few comments on these minutes that I'd like to make.
Would you like to go through each one individually?
I'm just going to speak generally, and the comments I'm going to raise, there are a couple specific comments, but in large measure they apply to all of the minutes. We say in a footnote that a copy of the searchable meeting transcript can be found on our website, and I think that's not yet the case with respect to a number of these minutes, so I just wanted to point that out. I think if we're going to post these on our website with that annotation, we need to close that loop. I would request that when we recite the law, our lawyers, the people who are present in the meeting, I would ask that we have a uniform format, and that we list their names and then their law firms, and then we say that they're legal counsel, and we kind of do that in a different way. I'd like to request that, given that Mr. Moratori attends every one of our hearings, that we spell the name of his application, his organization correctly, and that's in the May 12th minutes. And also that we spell Ms. Jerry Odeboni's name correctly, and that's in the May 31st minutes. There's some other typos that I'm not going to raise. In the June 29th minutes, we refer to Jean Clark she will be delegating her authority over the procurement of the mapping consultant to the commission in accordance with ARD 412112. That should be ARS section 412112. And then I think my last request would be that in the minutes of Thursday, June 30th, we refer to a number of individuals as representing self, and we have initial capital letters. And I think we can remove those initial capitals and just say representing self with lowercase letters. Thank you.
Thank you. Other comments?
Madam Chair,
Men?
I would agree. There were a number of what I would categorize as minor formatting and typographical issues. But substantively, I thought, and Commissioner McNulty identified a number of them, but substantively, I thought they were reflective of our hearing.
Thank you. Yeah, I had noticed mostly just proper noun misspellings. That was my own input, which we can get corrected before they're posted. Other comments from other commissioners? Is there a motion to accept these minutes, given the changes that Ms. McNulty suggested? So once those are made, they'll be considered approved.
So moved.
Second.
Any discussion? All in favor?
Aye.
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 Any opposed? Great. We'll work with Mr. Bladine to make sure those edits get incorporated, and then we'll get them posted on our website.
Madam Chair?
Yes, Mr. Sturts?
Because this is dealing with minutes still, may I just also make a recommendation that when, and I noticed that it was picked up on our website subsequently, but minutes were posted without the phrase draft on them. And I want to just remind staff that draft needs to be posted. We picked it up, but it took a day to pick it up.
Okay, we'll watch that. I didn't realize we had made that error.
It was a little missed, but I appreciate the fact that minutes are getting up in draft form and that transcripts in lack of minutes are being put up in lack of minutes. So I appreciate it.
Thank you. Okay. Any other comments? Okay, hearing none, we'll move to agenda item 11, discussion of future meetings. I know we have 2 on the books, I think, right now, tomorrow in Casa Grande at 10 a.m. and Monday. Is that, I should be looking at Mr. Bladine.
Yes, Monday in Tucson. I don't know that we have the location yet in Tucson, but it will be in Tucson. I believe we have it set for a 9 o'clock start time to be done by 3, I believe. I didn't bring it with me. That's the plan for Monday.
Okay, but the agenda for tomorrow, of course, is set because it's been posted. Have the agenda items been planned for the Monday meeting?
There would be some continuation of the items we had today, but the primary purpose again would be to review the submissions that the mapping consultants would work on over the weekend and on Friday in our office based upon direction you give them on Friday. So that's the main purpose of the Monday meeting will be to continue the mapping activity that you will begin tomorrow.
You mean on Thursday, right?
I'm sorry.
Yeah, no
Okay,
problem.
Correct, yes, yes.
We won't be meeting Friday. I know we
Right.
had talked about a Friday and a Saturday meeting, but ultimately,
Right. The
meeting
way
Thursday and Monday.
we ended up was Thursday, and then no Friday, no Saturday, but Monday coming back after the mapping consultants had a chance to follow whatever it is you'd like them to bring back. And that's as far as we've gotten on a schedule is Monday of next week in Tucson.
Okay.
Madam Chair?
Yes, Mr. Sturts?
And regarding Monday's meeting, from Strategic Telemetry, who will be there?
Madam Chair, Commissioner Sturts, myself and Willie Desmond and Green.
Madam Chair?
Mr. Herrera?
I don't, maybe I missed it, but there is, on this agenda, there's no discussion of future agenda items?
Hmm.
So I'm,
Yeah, normally, another catch, good catch.
what I wanted to do,
Yeah, this is just discussion of future meetings. I'm not sure if that can include agenda items.
I'd like to add a future agenda item, would it be for Monday? But I'd like to go back to the amendment that we, that was approved, or that, the amendment regarding strategic telemetry, making a log entry when they speak to members of the public, outside of public hearings and public meetings, because I would like for that to exclude the media, and that would include bloggers as well. So I see them as media as well, so I'd like for us to consider that.
That would be an agenda item for Monday.
Sure, maybe we can discuss
Okay.
it on Monday.
And what else is happening on Monday? Is Mr. Adelson also going to make a presentation?
That's correct, Madam Chair, and I'd forgotten. We thought we would put him on the agenda to give further information on the Voting Rights Act and what we need to do to comply.
Mm-hmm.
We'd also carry over an item, any items we didn't finish Thursday or didn't think we'd finish, and also the potential for a briefing on the activities of our legal counsel and the Attorney General's office. And I don't recall right now that we have any other items, but those are the ones that I can think of right off.
Okay.
And we can certainly later today circulate a draft list of items to all of you so you can see and add and subtract, send it back to us.
Okay, and it would have to be posted tomorrow?
We actually
Today?
could post on Friday.
On Friday, because Saturday
morning.
counts, okay. So we have till Friday.
Right.
Probably. Okay, good. Other agenda items that people have thought of or want to bring up now?
Madam Chair,
Mr. Sturts?
in regards to Mr. Herrera's suggestion, my question would be for legal counsel, will they have the opportunity between now and Monday to do a cursory legal review of the question that he's brought forward on the table?
Sure.
Thank you.
Madam Chair, I would just like to add that I think that's an important point that Mr. Herrera has brought up. I know we've approved a motion, but I would like to have further discussion about that issue Monday also.
Okay, thank you. Anything else? Okay.
Madam Chair?
Mr. Sturts?
Sorry, I just want to make sure that we put discussion of future agenda items on the next agenda.
We will do that. Yeah, normally it does say that, so we'll get that on there next time. That takes us to agenda item 12, call for public comment.
Madam Chair?
Oh, yes.
Just add one more agenda item.
Okay.
This will be quick. Mr. Bladine, during his report, talked about the progress that they're making in reaching out to members of the community through the website, public hearings, and I want to make sure that that's part of every meeting. I think it's important that we educate the people that are in attendance and also the commission the work that we're doing in reaching out to members of the public via the website, public hearings, all the different forms that we're allowing and encouraging members of the public to make input and to reach out to the commission. So I would like an update every meeting.
I would agree. I think those statistics are powerful, and I think it's worth talking about them, and maybe our public information officer can help with that too, Stu Robinson. Thank you. Okay, moving on to agenda item 12, call for public comment. This is the time for public to comment on items on the agenda or redistricting maps. Members of commission may not discuss items that are specifically identified on the agenda. Therefore, action taken as a result of public comment on matters not on the agenda will be limited to directing staff to study the matter, responding to any criticism, or scheduling the matter for further consideration and decision at a later date. And I have a number of request to speak forms, those that we already covered on specific agenda items. And then I have a number of others here that we'll go through. And again, for our court reporter, if everyone could be sure to speak directly into the microphone and spell your name so that we get an accurate accounting. And if you could also say where you're from, what city, town, or county that you reside in, that would be great. So our first speaker is Representative Albert Hale from the Arizona House of Representatives, representing LD2 and Navajo Nation.
Yat-e, I don't know how to spell that. Yat-e to Ahihat. It is good. So Yat-e Ahihat. Thank you. I'm called Albert Hale, representative, legislative district number 2, which is the northeast corner of the state of Arizona. I've been a representative for 1 year now, but I served before then in the Arizona Senate for 9 years. And I've also been the president of the Navajo Nation, chairman of the Navajo Nation Water Rights Commission, so you can call me representative, president, senator, chairman. What did I leave out? Something else, whatever. Anyway, I just want to address a number of issues with you. I spoke with the commission, at least the two who were present when you had your public meeting in St. Michael. At the time, I mentioned a number of things that I think is worth repeating in light of what you have done so far. What I understand that you've done so far is to produce a grid map, basically coming up with, as I understand it, coming up with a map that is based on population and how you would draw a map solely based on population to come up with an equal number of population in the different legislative districts. So I think you've done your task there, which to me, it seems like that's the easy part. But the difficult part lies ahead. The harder part lies ahead. But this gives you, as I understand it, a jumping off point, a reference point, so that you can now apply other requirements, including community of interest, which I want to speak at, retrogression, and dilution of voting. Those are some of the things I want to speak at. In the grid maps that you have produced for the state of Arizona, the legislative district, and I want to address the legislative district maps first. What I see has happened based on the population is that populations that have existed historically together have been split. If you look at the legislative district that I represent, which includes 5 Indian nations, the Navajo Nation, the Hopi Nation, San Juan Paiute Indian Nation, Wallapai and Havasupai Indian nations down the canyon, and the City of Flag. If you look at those communities, those nations, particularly Navajo Nation, they have existed in these parts of the state long before Arizona became a state. But in this grid map that you have, now you're splitting them up because the line that I saw goes on the western Navajo County line is the line that cuts them off. But Navajo Nation goes beyond that into Coconino County. So that's a problem. And that has to be addressed in order to meet those other requirements that you have to take in consideration. So immediately what that does, if you're going to draw the lines that way, there are a number of issues like dilution of voting by Navajo people. Their votes are going to be diluted if you keep the map as it is. And then this will also result in retrogression, which is something that is prohibited, as I understand it, in the Voting Rights Act. If you pursue the grid maps and allow that to be in place, then what is happening is that the current LD2, which is my legislative district, you now have 30 or 63% Native American in that district, which allows that district to send consistently, and they've done this consistently, a Native American to the state legislature in both houses. That has never happened before, but it's happening consistently with the type of legislative lines that you have with legislative district number 2. And you're going to be moving away from this if there's no adjustments made. There'll be retrogression, like I said, and the 63% Native American in this legislative district will be reduced to a real smaller amount, I dare say probably to 25%, 30%. So that's an issue that needs to be addressed. And lastly, which I mentioned earlier in my presentation, is the splitting of people who have commonality and people who have lived together, communities that have been treated as a whole for centuries. They have common issues, common interests, splitting the Navajo Nation and other Indian nations. So that's the other issue that I think needs to be addressed. The other one that applies generally not only to legislative districts, but also to the congressional district, is the community of interest. When it comes to Native American people, community of interest, from my perspective as a Native American, and I dare say from the perspective of all Native Americans, is the fulfillment of treaty obligations. And that stems from the recognition by the United States government that Indian nations are sovereign from day one. That means Indian nations have existed as sovereign entities long before the formation of the United States and the state of Arizona. As a result, the Constitution did not apply to Indian people for a very, very long time. Indian people, Native American people, have been here from time immemorial. But under United States federal law, they were not declared to be citizens of these United States until 1924. So first here, last to be citizens. And on the voting issue, Native Americans were not given a right to vote, and they had to fight for it until 1935 in Arizona. And even as late as 1970, when in Apache counties, the Navajo people, for the first time, elected a Navajo to the Apache County Board of Supervisors, there was opposition. The opposition from the county that's outside the Navajo Nation filed a lawsuit to stop the supervisor that was voted in by the Navajo people, Tom Shirley. And the Navajo Nation had to go to court to secure his place, and by doing that, secure and affirm the rights of Native American people to vote. And that was only done in 1970. And once that happened, Now you're beginning to see a move in the direction where I think we're finally beginning to realize that Native American people are citizens of these states. And as citizens of these states, they are entitled to all the rights that are afforded to other citizens outside Indian nations. So I bring these to your attention because I think those are the things that need to be addressed in what you have before you. What I would suggest to you in terms of the LD2, the legislative district, and the grid map that you have before you, is to work off of that legislative district as it now is composed. I know that that legislative district has lost a tremendous amount of population. And the reason why should be very evident. The legislative district, as I mentioned before, consists of 5 Indian nations. And Indian nations, because they were put on reservations, all the development, economic development, everything else, bypass Indian reservations. So now you have Indian reservations that are similar to third world countries that exist here in the United States. And for that reason, a lot of our young people, Native Americans, are moving off the reservation. And they're moving to cities like Phoenix. And I believe that in the last count, the last centennial count, Phoenix has about the 3rd highest population of Native Americans. The city of Flagstaff, or the city of Albuquerque being number 2, and the city of LA being number 1. So there has been a shift away from the reservation because there's lack of jobs there. There's lack of economic development there. There's lack of opportunities, educational and otherwise, on Indian reservations. A lot of the population has moved to what we call the border towns. For example, the city of Flag has a significant Native American population, and for that reason, they are part of legislative district number 2. The city of Winslow Holbrook has significant Native American population, but currently they're outside legislative district number 2. My suggestion, my recommendation is to add those border towns to legislative district number 2 to pick up the population that has been lost. And you have a reason to do that because of the significant population of Native Americans in those towns and cities. In addition to that, because we are, and part of the definition that you're looking at in terms of the community of interest is religion and culture. People who have commonality in those areas, religion, culture, history. There are lands that Indian Nation own outside Indian reservation. For example, Navajo Nation owns the northwestern part of the peaks, even though it's off the Navajo Nation. And they also own the Big Boquillas, right there outside of Williams, the Big Boquillas Ranch. And they also own some tracts from between Winslow and Hobo. And the Hopi Nation also owns land tracts around Winslow and all the way down to Eager. So if you add those lands that are owned by Native American nations, you can pick up those population also. And I think that will help you get to meeting or complying with the requirement of community of interest. So I offer that to you. I offer that to you as a solution. And I know the Navajo Nation has considered a number of options, and it has come up with its own options, not only with regard to legislative district, but also to the congressional district. So that deserves an examination on your part to meet these requirements. So I won't get into the legislative district aspect of it, but I think that you're picking up in those, the congressional district. If you're looking at the congressional district, you'll have the same type of problem in terms of community of interest, which is the Indian nations that are in those CDs. Their primary interest is going to be fulfillment of treaty obligations. And those obligations are obligations of the federal government and also of the state. They're obligations of the United States. And there are treaty promises that promise that Indian people, in return for moving to Indian reservations and agreeing not to go beyond that anymore, and all their indigenous lands being taken, they were promised all these things. A right to education, health, social assistance. All of those things were promised, and Indian people have paid for that already. So those are considerations. And I urge you to take a look at that and take a look at my suggestions. And I thank you again very much. And I'm glad to see that you're planning to go back up to Window Rock, for those of you who missed the last trip. It's a wonderful place. And I would also add that the Navajo Nation is larger than the state of West Virginia. The Navajo Nation is larger than most of the counties here in the state of Arizona. So on that basis, I would highly recommend that in addition to having your next hearing in Window Rock, you add Kayenta, which is the northernmost part of the Navajo Nation, almost close to the Utah line. And then also add Tuba City, where Tuba City is the largest community on the Navajo Nation. So I would urge you to do that so you can listen to my people and have them be given an opportunity to express their desires regarding the task before you. Thank you very much. May the holy people be with you always. Thank you.
Thank you. Continuing in that same vein, our next speaker is Leonard Gorman. Well, before we just announce that, I'll ask legal counsel. I know we have a meeting noticed for 4 p.m. I'm not sure if I thought you were allowed to start those meetings later as long as it was noticed by 4, but I don't know if there's a time limit as to when we need to start it by.
Madam Chair, there is a separate meeting notice for 4. I think if you let the public know that this meeting's running late, so that meeting will also start late. I think that's appropriate.
That's enough. Okay. So our meeting at 4 p.m. will be starting later than 4 p.m., and we'll continue with our public comment. Leonard Gorman, Executive Director of the Navajo Nation Human Rights from Window Rock, Navajo Nation.
Madam Chair, can I make a quick suggestion? Let's stick to a 4 or 5 minute time frame.
Okay, is everybody?
How about 4?
Okay, we'll go with 4 minutes if everyone could try to provide their input, but if you go over, I'm not going to pull you off, so I'm just telling you. Thank you.
Good afternoon, Madam Chair and members of the Commission. I'm not going to take a whole lot of time on behalf of the Navajo Nation Human Rights Commission. I sincerely express the appreciation to the Commission coming to visit with us in St. Michael's, and we're looking forward to the September meeting again up there. And whatever help we can provide to the commission to feel comfortable in our neck of the woods, please have your staff call us in advance, and we'll be helping them make those arrangements. At that meeting in St. Michael's, I mentioned to you that the Nomination Council was in session at that point and had been considering the maps for the state of Arizona, New Mexico, and Utah. We have made significant progress in those areas, and I will be submitting the written portion of the Navajo Nation's recommendation for the state of Arizona for Legislative District 2 and also the congressional district in the northeast corner of the state of Arizona. Just to highlight some of the comments that were made about the definitions. I think it's important that the definitions be written. I noticed that the definition of community of interest is an important aspect to the Navajo Nation and the Navajo people, and how those languages are being to be devised and the words that are going to be used, I think is very important to the Navajo people. As an example, while ethnicity is an integral part of the Navajo people, and it says people, a group of people as a community of interest, also not only as a group of people, as people with land base. That's a distinct, unique land base, I think is a very interesting part of the community of interest, particularly indigenous nations throughout the state of Arizona. So we look forward to having you publish the languages on the specific terms, and we do echo the presentation made by Representative Hale, and look forward to having to make further presentations in the future. Thank you very much.
Thank you. Our next speaker is Steve Titla from San Carlos Apache, Gila County. I'll go ahead and read the next few names too. Jean Dufault, Andrew Sanchez, and Karen Cushing.
Good afternoon.
Good afternoon.
Redistricting Committee, I commend you for doing a very difficult job for the state of Arizona, in the congressional, legislative, and districts. And I spoke to you in Honda. I don't know if you remember me, to the two Madam Chairman and gentlemen. I was in Honda, White Mountain Apache. But I'm from, I'm from San Carlos Apache, and I looked at the maps, the grid map that you produce here, grid map option 1 and option 2. I'll be referring to these two maps, and I'll try to keep under 4 minutes as the gentleman requested. You know, I was looking at the definition under the Voting Rights Act. As you know, everybody knows about compliance with the Voting Rights Act. And I was looking at the definition for community of interest here. And that fits the San Carlos Apache and the White Mountain Apache, Navajo Nation, and the tribes together, I would think. Because we as Apaches, we have common interests in religion. We have political ties, history, tradition, geography, ethnicity, culture, socioeconomic status. So all of that kind of fits us very well, that definition. And with respect to communities of interest and significant detriment, I think that any split in our vote or dilution of our vote or retrogression in our votes would really have significant detriment to effective representation of the native tribes in Arizona. And looking at your option 1 map, it seems to split the San Carlos Apache reservation already. And for sure, it splits the White Mountain Apache reservation. And then it splits the Navajo Nation, and maybe Hopi too, is what it seems that. I don't speak for those tribes, but it's what it seems to do. That's what your option 1 map does. And I think that is contrary to the communities of interest definitions that we're trying to work toward. Your option 2 map does the same thing too. I think that it seems to split San Carlos Apache reservation. I would like to have a bigger map to look at, but it seems to split us already. And then for sure it splits White Mountain Apache reservation, and it splits Navajo Nation. Hopi's not in there. So a lot of the native tribes in Arizona seem to be split, and that would dilute our vote. and that would give us no chance to send any sort of representation to the congressional district or the legislative district. And we, San Carlos Apache, we are a treaty tribe since 1852, and under international law, we're recognized as sovereigns prior to the U.S., as Senator eloquently stated. And so as you work forward to this, we are going to provide our input. And I think that San Carlos Apache will be providing input as they go along. But today I speak for myself here, and thank you for going forward here. And I saw that you'll be in San Carlos in one of your visits, so we welcome you to, when you get there, to Apache land, and thank you.
Thank you. Oh,
Steve Titla, T-I-T-L-A.
Thank you. Our next speaker is Jean Dufault from Mesa.
Hello, my name is spelled G-E-N-E, Dufault, D-U-F-O-E. And Chair and Commission, I object to the deferral of the open meeting law for the Commission. It's very important that you have the benefit of this training with communications outside of the public meeting. If you have not had this, it's very important that you do have it. The public needs confidence that the Redistricting Commission is in compliance with the open meeting law. And there seems to have been a number of objections from the public that is being investigated by the Attorney General. So I don't want to defer this when this is such an important decision to make. And that will complete my conclusion. And now, what is your response?
We cannot respond to members of the public on this, on any item, actually. So our next speaker is Andrew Sanchez, council member of the town of Guadalupe from Maricopa County. If he's here. Okay. Put that aside. Karen Cushing, representing self from Cave Creek.
Hello, everyone. Karen Cushing, K-A-R-Y-N-C-U-S-H-I-N-G. I've been to a few of these redistricting meetings, and I'm just a little bit concerned about how our state is going to look when the maps are complete. You know, all this talk about communities of interest and competitiveness, when really, what does that mean? I mean, does any of that matter when you guys have hired these companies such as Strategic Telemetry, and now I just hear of this other company by the name of Catalyst. I don't know, I guess it's a software company, who have a specific agenda to transform our state into a liberal progressive voting bloc. I object to the Arizona Independent Redistricting Commission and Strategic Telemetry's hiring of Catalyst, a data mining company, micro-targeting organization who promotes a progressive agenda and promotes candidates and organizations such as the ACLU, Arizona Democratic Party, La Raza, SEIU, and the AFL-CIO, just to name a few. This sounds like gerrymandering to me. I don't understand why the AIRC could not have just hired a company out of Arizona, and why they had to hire this out-of-state company at all. I mean, why couldn't you guys have done this redistricting yourself? I don't understand. I mean, I know you can't tell me, but I'd like to know. Now I hear that the taxpayers here in Arizona are having to pay somewhere in the amount of $600,000 for strategic telemetry. I just want this to be a fair and nonpartisan process. That's all. Thank you.
Thank you. Our next speaker is Brian Birkeland, representing Self, and you'll have to tell us where you're from, Brian. And that he'll be followed by Pete Bankson, William Engler, and Moher Sidwa.
Hi, my name is Brian Birkeland, spelled B-R-Y-A-N-B-E-R-K, L-A-N-D. I'm from Mesa, Arizona. I live here in Arizona. I take my representation in Washington, D.C. very seriously, and I've been following this commission. It seems to me a number of the decisions this independent commission has made are fishy at best. And, you know, what I really just want to say is it seems to me that strategic telemetry, in conjunction with this Catalyst organization, has the ability, you know, and intention, I would say, to engineer congressional redistricting in anything but an independent and technical manner. The level of technology and database information that's available today, unavailable to prior census data and redistricting, is, it'll allow these companies to continue their progressive agenda and profit from it right underneath your noses without even really knowing about it. It's such a technical manner that they're incorporating into this redistricting process that it takes the fringes, the people right on the fringe, and it allows these organizations to really manipulate the information without you guys even really being able to see how they're manipulating the lines, the redistricting lines. So I just caution you guys, and I want you to realize, you know, that this is my main concern, that these guys can really, underneath your noses, sway how my vote is counted on the national level. And I don't agree with that. I don't agree with a number of the things that this commission has decided, but I'm going to leave you with a closing statement here. And that is that the commissioners should remember that a flawed process will bring flawed results, and a tainted system will just add to the skepticism of the American people. Thank you.
Thank you. Our next speaker is Pete Bankson, representing Self from LD 26.
Good afternoon. Good afternoon. My name is Pete Bankson. That's B-E-N-G-T-S-O-N. I live in Pima County, LD 26. First, I want to repeat what I normally say. I really support the commission, especially Chairman Mathis. I think you're doing a great job. Keep it up. I also support strategic telemetry. Normally, I go on and then talk about competitive districts, but I'm going to switch topics now and talk about measurement. I'm a retired engineer, also got a master's degree in systems analysis, and I firmly believe in measuring what your goal is. If you can't measure what you're trying to do, you can't tell whether you're getting there or not. I believe you really need to have some kind of measurement for competitive, contiguous districts. I think you ought to really add in another measurement for this geographic dispersion, the boundary lines thing. You're supposed to have boundary lines that follow city, town, and county boundaries. And that's just as an important goal as competitive districts or any of the other goals. I can see how you can measure competitive district. Professor Steen mentioned one way to do that, and I want to follow up on some of those definitions. This communities of interest has bothered me ever since I've been hearing people support communities of interest. I can easily see how Indian tribes are communities of interest. I live in LD 26, and you've heard a lot of testimony of the northern part of LD 26 seeing themselves as a community of interest with Oro Valley and Marana. In the suburbs, I just can't see community of interests. The people are very differentiated, where you go to church or where you shop or where you play bridge or where you recreate. Doesn't strike me as a valid community of interest. I can sort of see the rural-urban boundary distinction as a community of interest, but the only one that really makes sense to me is Indian tribes. And thank you, and see you tomorrow.
Thank you. Our next speaker is William Engler from representing District 6 Democrats from Maricopa.
Thank you, Madam Chair, Commissioners. First off, the name is Bill Engler, E-N-G-L-E-R. I live in Anthem. I want to thank you, all of you, for the job you've done so far, and I commend you for taking the heat you've been taking up until this point. I speak from the perspective of a chair of a district that is not competitive. My district, as well as too many others in this state, the results are handled at the primary stage. So I believe that disenfranchises so many voters because they don't have an incentive to come out and vote because they know their vote doesn't count. I know you've got many criteria you have to look at in your deliberation, but I believe you can arrive at just conclusions and also have competitive districts to a far greater extent than we enjoy today. Thank you very much, and continue the good work.
Thank you. Our next speaker is Moher Sidwa, followed by Jim March, Betty Bankson, Ken Clark.
Well, hello again. A slight variation on a theme today. Yes, I'm still for competitive districts, and I will still use the same definition. And like the previous speaker said, when we hand over selection of candidates to a party rather than to the public, it's a selection and not an election. Because this leaves out the independents, the libertarians, the Greens, and those who are genuinely independent. And this does dilute the application of democracy, and it is dangerous. And it has happened in other parts of the world constantly. I've lived there. This must not be allowed to happen in Arizona. So we have to look at competitiveness. The other issue that I spoke about last time, I want to speak about a bit more, is about inmates. Inmates cannot vote. Then they should not be counted for the purposes of redistricting. Using inmates when counting populations is important because it leads to voter disenfranchisement. In general, counting prison population as residents of that district artificially inflates the population because these people cannot vote, and those small towns nearby wind up getting twice the bang for their voting buck. And instead of one person, one vote, we are looking at destruction of the 14th and the 15th Amendment right there. It violates the equal protection of the 14th Amendment and the minority voting principle of the 15th Amendment, which taken together creates the one person, one vote. And the moment you put a district, an LD, like somebody had once suggested that gave me the creeps, stretching from, say, Florence to Yuma, you're looking at a very diluted district. So just be alert to that. I don't know who has to be alert, but I suspect now that all 5 of you are aware of it, you will make sure that you are alert to it. Prop 106 faces its final criteria for redistricting requiring competitiveness unless there is a substantial detriment to other criteria. I would like to emphasize the word substantial. Bike paths, doctor's offices, incumbency protection are not substantial. What Representative Hale mentioned earlier, that's substantial. That's a community of interest. And so we're looking at the nations in northern Arizona as well as in southern Arizona, just kind of keep that in mind. Most of the people who have been urging community of interest is important have given their reasons, which to them I'm sure are very valid, wherever they ride their bicycle or jog or whatever. It just concerns me that they would sell the uniquely American concept of a competitive democracy as enshrined in our Constitution and its amendments on such trivial grounds. Yes, they don't think it's trivial, but those are. Competitiveness is important. Or equally horrifying, setting our system of government for the sake of protecting incumbents. This must not be allowed to happen here. A lack of competitiveness hurts the very concept of democracy by making a mockery of the democratic process, and that's un-American. Yes, I would certainly keep certain communities of interest together, and it doesn't take a rocket scientist to know what a community of interest really is. The Navajo Nation or other nations together. And you need to talk to those people, be it in Window Rock or wherever, and find out from them and take it from there. Thank you very much.
Sorry, Ms. Sidwa, do you mind spelling your name for the record? And I should have said representing self from Pima.
Yes. First name M-O-H-U-R, middle name Sarah, S-A-R-A-H, last name Sidwa, S-I-D-H-W-A. Thank you.
Thank you. Jim March, second vice chair, Pima County LP.
Libertarian Party.
Ah, thank you.
Thank you. Folks, I appreciate your being here. I'm glad I'm able to come. First thing I'd like to say to you is something I've been wanting to say in previous meetings. My understanding is, well, I've actually seen various people make a lot of light of the fact that the AG is apparently investigating you, and they've used that to kind of harangue you in a straighten up and fly right kind of a manner. I just want to point something out, and I'm sorry, somebody's got to say it. Tom Horn, our Attorney General, was thrown out of the stock market by the SEC for life for a number of ethical problems. So if Tom Horn is investigating your ethics, I find that downright weird. Okay? I find that really funky. So if you're concerned about the fact that Mr. Horn is investigating you, keep that in mind, is that he may not be the best qualified person to do so. The other thing that I've looked at is the grid map. I guess they're a preliminary view, a starting point, if you will, on how you're going to do the maps going forward. And that's fine so far as it goes. And you have set 1, congressional and legislative, and set 2, congressional and legislative. Well, as you progress with this process, I'd like to urge you to take the set 1 maps, both the congressional and legislative, and toss them in a nearest fireplace and use them as kindling. And the reason I say that is the classic gerrymander was Governor Gerry of Massachusetts 199 years ago, came up with a squirrely looking map that looked like a salamander. It's why we call it gerrymander ever since. When you've got really screwy looking districts, bent and misshapen, it's a sure sign that something has gone wrong with the process, either deliberately or accidentally or somehow. If you look at the congressional district maps for the set 1, they have 2 huge bookends either side of the state running top to bottom. So on the east side, one congressman is supposed to be dealing with issues on the southern border on one day and then issues with Apache and Navajo counties on the next day. That just seems bizarre to me. And when I looked at the map carefully, I was realized in horror, there are a pair of vertical lines that are curving inwards. I looked at it and said, oh my God, they're turning Arizona into Darth Vader's spaceship, which would put old Darth himself right somewhere around Camp Verde, which is downright bizarre. If you look at the map 1 legislative districts, you've got this one huge district flopping from the left all the way over the top. Oh my God, it's Donald Trump's comb-over. But look, seriously though, seriously, funky looking maps, we can laugh at them, but they're a sign that something went wrong with the process. Obviously the the set 2 maps still need a lot of work. We understand that. But to me, at least using the low-res maps we have available so far, they look like a much better starting point. I'll add one last thing. I will be real quick with this. If you have 2 districts that are sitting next to each other, normally, if you have a long squiggly line reaching into the other district, curling around something and coming back out, that's a bad thing. But if that's what you have to do to solve the prison issue, to spread, what you should be doing is what Ms. Sidwa just asked you to do, is ignore the prison population if you can, but if you can't, if the law forces you to include the prison populations, God forbid, the detention centers, in your process, if you have to, then you should be spreading the prisons out among the various districts to minimize their imbalancing effects of putting them all in one. And if you have to do long, funky line, reach out, one district grabs that prison, comes back, that particular kind of weirdness can be accepted for the purpose of negating the harmful effects of piling all the prisons in too few districts. And with that, I'll close out. Thank you very much.
Thank you. Our next speaker is Betty Bankson, representing Self from LD 26, followed by Ken Clark, Bob Rosenberg, and Lynn St. Angelo.
My name is Betty Bankson. That's Betty Bengtson. And I live in Pima County, LD 26. I came today prepared to talk about competitive districts and communities of interest, and to urge the Commission to come to some agreement on definition for what those are. And I was pleased to see that you do have that under consideration. I'm a little disturbed that there seemed to be some uncertainty as to whether you really wanted to come up with those definitions or not. And I certainly urge you to do so. I particularly commend to you Professor Steen's comments about competitive districts and communities of interest. As I had thought about communities of interest, I really had been somewhat confused as to what they are. People, again, had talked about where they shopped and where they played bridge or recreate or whatever. And I was quite happy to hear Professor Steen articulate the importance of the interaction between a community of interest or communities of interest and how they might be affected by actions in the legislature or in Congress, and how important that is in deciding what is actually a community of interest that is important with regard to redistricting. So again, I would hope you would take a really close look at those comments and give some serious consideration to coming to an agreement on definitions for the various goals and criteria that are prescribed for your work. Thank you.
Thank you. Ken Clark? Yeah, okay. Bob Rosenberg, representing Self from Phoenix. Okay. Lynn St. Angelo. And following Lynn will be Wendy Shops and Lara Mermaid.
Commissioners, it's Lynn St. Angelo, LYNNEST_ANGELO, and I'm from Oro Valley in Tucson. I, too, since we're giving credentials, have a Bachelor in Science and Mathematics, so numbers are very important to me as well. The competitive definition, I think if you can get 7% or less, you're doing really well. Since the numbers in Arizona with voter registrations are 36% Republicans and 31% Democrats, if you count that a certain way, that is 6 already spread points apart. So to get to 7 or less in every district is going to be quite a challenge. The 33% of independents do swing the vote. If you look at the voting records, you'll see that they swing it different years one way, different years another way, and they really are the vote that's determining the outcome of the elections pretty much. To use election polls, as was suggested by, I think, the professor, those are really not measurable. They depend on what polling company you use, and how you even look at it. Many times polls are wrong. So I would say that is not a hard number that could be used in any case, and that you shouldn't really even consider that. And so that was, because that was brought up earlier, I wanted to talk about that for just a minute. The other thing I would suggest is that when you put something in the minutes, like this new company that we didn't hear about before, this Catalyst company as a subcontract, that you spell it out so that we can look it up online and find out about the company before the next public hearing. We knew that strategic telemetry in their RFP had said they didn't need any subcontractors. Now all of a sudden we're going to be paying for another company, another out-of-state company using taxpayer funds. And when we Googled Catalyst, we got a very far left, ultra-progressive liberal company that may or may not be this company that you actually are considering, simply because the information that was provided in the minutes weren't sufficient. So if that isn't true, then I'm going to apologize for what I have to say, because I'm going to tell you what we found, okay, why this raises real red flags to us in the public. Laura Quinn is founder of Catalyst, and their clients have included strategic telemetry, the DNC, every Democratic presidential campaign from 1996 through 2008, and a wide range of progressive organizations and nonprofits. They said they provide data and related services to progressive advocacy and not-for-profit organizations, campaigns, consultants, and academics. Catalyst maintains and constantly updates a complete national database of 265 million people, more than 180 million registered voters, and 85 million unregistered adults. The Catalyst also derives synthetic data through modeling, offering insights about persons such as relative likelihood of turnout to vote, likelihood to be married or have a college degree, to name just a few. Some state voter data may not be available to certain customers based on applicable state voter data laws. And then they said they have no other mission than to serve the data needs of the progressive community. If this is not the company you're using, I apologize, but next time please put in the information on your agenda, the correct information. Thank you.
Thank you.
Madam Chair, I believe that was on our agenda so we can make a comment. Is that correct?
O'Grady, is that okay?
It's a different company. It's spelled differently. It's not spelled the way the company on our agenda was spelled, just to reassure Ms. St. Angelo. The two companies are completely unrelated. The company that will be providing document management for services for us will only be doing the kinds of things that we talked about during our agenda item.
Thank you. Wendy Shops, Sons of Liberty Writers, and she's the president.
WENDYSCHOPS. I'm the president for for this group here in Arizona, and one of the things that we talked about the last meeting that's been addressed today is the definitions, and I really appreciate this jumpstart on getting this out to the public. As you know, I've attended several of these meetings, and what concerns me is these terms, competitive districts and communities of interest. What this seems to be doing is causing a lot of division within our state. There's so many communities of interest that have been brought up throughout these meetings, culturally, religiously, language barriers, whatever it may be. And what I want to say is that we're Americans. We're not supposed to be saying we're from this country or this country and having these divisions. And I would like the commission to take that into consideration. This redistricting is about population. And if we keep focusing on communities of interest, it's just going to make this more difficult and complex. As much as I appreciate and respect all of the cultures in our state, I still want us to one point say we're Americans. So please don't take too much when people come up and talk about every single thing about their community, because we really are one community. Thank you.
Thank you. And our last speaker, at least the last request to speak form I have, is Larimer Mace, representing South from Yavapai County.
My name is Larimer Mace. First name's L-A-R-A-M-E-R, last name M-A-C-E. Speaking first on the grid maps that were provided, it looks to me like what has been done is you've given us one map that is so terrible that the other bad choice looks halfway decent. Neither of them is acceptable in my mind. I am a member of the Yavapai Republican Committee, but I am speaking for myself and a number of friends who could not afford the trip down here from the Verde Valley. I assume that none of you have served as precinct committeemen, or you would recognize that the LD options are a joke. Legislative districts hold monthly meetings. On your grid map 1 option for the legislative districts, was explained before, we have a district that runs from the western edge of the state, all the way across the northern, all the way down the eastern, almost to the southern border. If they're holding a monthly meeting, question number 1 is where would that meeting be held? And number 2 is how are they going to get there? The districts, the legislative district particularly, must be as close to a square as you get. My current district, LD4, runs from Seligman at Highway 66 to Bell Road in Sun City. The Yavapai County portion is very sparsely populated. Therefore, the majority population is in Sun City. Guess what? The meetings are held in Sun City. So our PC committeemen in Seligman would have to drive over 200 miles one way to make a monthly meeting. This is ridiculous. They don't go. I myself have to drive over 100 miles to get to a monthly meeting. Yavapai County is mostly rural, and except for my age, I have absolutely nothing in common with Sun City. I could care less when they get speakers from the Sun City Fire Board candidates. Therefore, I have nothing in common with them. Likewise, the people in the Verde Valley have nothing in common with the liberal academics of Flagstaff. Yavapai County would prefer to be a single legislative district by itself. Our population base is within 2% of the required population. Therefore, likewise, it comes about as close to a square as you can get. Likewise, Yavapai County would prefer to be completely within whatever congressional district we're put in. In conclusion, I'd just like to say that Yavapai County does not want to be used to balance other districts, as most of these maps show. We want to be a single entity. We have a common interest, common goals, and if you split us up, we're going to scream bloody murder. Thank you.
Thank you. Are there any other requests to speak? Anyone that would like to address the commission? Okay, seeing none. That takes us to the adjournment of this meeting. I don't know what's the proper procedure here, if we're recessing and moving into the next meeting or just adjourning. We need a break, so is it okay to adjourn and we'll start the next one? Great. Okay, given that the time is 4:50 p.m., this meeting is adjourned. Thank you all for coming and for your input and your patience.